administrative order, an emergency clarification order, guidelines, or even just a report. As a former legislator, I'm very sensitive to not only the role and intent of the General Assembly, but I would also like to make it clear that we're not here today to relitigate the policy directives of the Indiana General Assembly. I've asked the Commission's General Counsel, Beth Helene, to moderate today's conference. We want to be respectful of everyone's time today and use it wisely, so Beth will review the processes and procedures and will proceed accordingly. I've also asked Beth to do an overview of the Commission's current interconnection rule. I want to be very clear. If customers have followed the interconnection rule and complied with the statutory grandfather date, then any additional time needed by the utilities will be the responsibility of the utility and not adversely affect the grandfathering status of the customer and the net metering facility. With that, I yield to Beth Helene, our General Counsel. Beth?
Thank you, Chairman, and good afternoon and welcome. As he mentioned, my name is Beth Helene. Many of you will know me by my former name, which was Beth Rhodes. I used to have a great joke about my name and my email address because B. Rhodes, the way I spell my name, actually spells Broads. And IoT, our internet access people, were kind enough to let me use my middle initial. And so last February, I gained a wonderful husband and lost a joke. So in addition to those who have already been introduced, I just wanted to introduce those who are helping out today. We have Stephanie Hodgen, who's working with media. She's in the far back. We have Ryan Hadley. So if we need to actually queue up to get to the microphones, he'll be handling that. And then in 224 and helping out, actually, Ryan's in the outside room. Ryan, come in here. Okay, yeah. So, and then I have two of my staff, Jeremy Camo and Brad Pope, who are Assistant General Counsels, who are also assisting with overflow into 224. And just so you're aware, the video stream is actually being shown live in 224 as well.
Hey, and Beth, I also see Brad Borum and Bob Pauley back there, a couple veterans from the commission. You want to raise your hands? I don't know if they were on your list or not. Oh,
they weren't on my list, but we always welcome them. And Jane Steinhauer.
Oh, Jane, you got to sit up straight so I could see you. There's Jane Steinhauer, the head of our electric division, energy division.
So thank you all. Hopefully you all picked up a copy of the agenda and handout. We have paper copies, and both are also available on the Commission's website if you are viewing this conference online. There is a correction to the handout. If you all turn with me to page 6, line 29. There was something that didn't get printed. And so line 29, there should actually be a 2 in parentheses there, and the date of July 1, 2032. So that correction to the handout that was passed out. And again, so this handout has copies of the statute, the net metering and interconnection rule, as well as all the comments that we received. It's paged as one document and with line numbers. So my goal is that we'll all hopefully and literally be on the same page. As the chairman mentioned, the commission would like to ensure each agenda item is addressed and that all parties have the opportunity to ask questions, provide comments. We ask for your cooperation to help make this happen. Because today's discussion could be the evidentiary basis for a possible commission order, today's discussion will be transcribed by the commission's court reporters, Linda Rubel, who you see before you, and Amy Tokash, who'll be joining us later. In order for them to do their job, only one person can speak at a time, and you need to speak slowly and clearly into a microphone. Those sitting at the tables have access to a microphone in front of them. You need to make sure that you push the button of the red lights on in order for it to work. We do want to hear from everyone in the audience who has a question or a comment, but you still need to speak into a microphone, and for that purpose, we have an empty seat here at the far end of this table. And what we'll be doing, if you have a question or comment, feel free to raise your hand. Ryan or Stephanie will help line people up if there's more than just one, but then we'll have you come up to this seat and microphone, and please state your name, and if you're with an organization, if you're representing somebody, what organization you're with. And then we'll be using the chairs along the wall if there's more than one person that wants to come up to the microphone at a time. So Ryan and Stephanie, again, are going to be handling that kind of queue up process. We don't want anybody just standing up. For those of you who were at some of the hearings in the General Assembly, they literally had people fainting within the first 45 minutes. We're trying to have a safe, healthy conference today. So please don't try to just stand along the wall, and we don't want to have any issues along that line. As we move through the agenda, I will introduce the topic, including who provided questions and comments on that topic, and I will call on those who provided those written comments on the topic. If you have additional comments and questions on the listed topic but have not been called on, again, please raise your hand. Just makes us for an orderly process so we can make sure people can have an opportunity to provide their comments and questions. Please remember that today's focus is on the implementation of Indiana Code Chapter 8140, specifically those provisions affecting the December 31st grandfather deadline. Because the Commission is required by statute to remain impartial and to base its decisions on the evidence presented in the record in a case before it, we will not be discussing those aspects of the statute that involve future decisions by the Commission. Also, I know there are a lot of questions on Section 23 of the statute regarding customers' rights and the rules to be adopted by the Attorney General. Betsy Eisenberg is here, as well as a staff member from the Attorney General's office. But at this point in time, she's here to listen to this discussion and will not be answering questions today. While the Commission staff will be providing whatever assistance the Attorney General's office would like, that rulemaking is their responsibility, is outside of the scope of the Commission and what we will be discussing today. In addition, as previously noted, we will not be discussing the policy decisions of the legislature. Of the legislature, excuse me. So to start us off, we will go through an overview of the interconnection rule. That's on pages 14 through 26 of the handout. So we'll provide a brief explanation of the current interconnection rule, because we think this will help inform the discussion and even provide some answers to some of the questions that were submitted. So first of all, let me just say that only the applicable portions of the rule apply to net metering and distributed generation as defined in Indiana Code Chapter 8140. Please remember that the interconnection rule applies to all kinds of interconnections, not just net metering or distributed generation. Therefore, there are some terms in the interconnection rule that don't apply to net metering and distributed generation, particularly as defined in Indiana Code Chapter 8140. For example, the interconnection rule refers to third-party owned infrastructure. That's on page 14. However, under the statute, net metering and distributed generation is defined as 1 megawatt or less and customer owned. Thus, that portion of the interconnection rule regarding third-party ownership does not apply to net metering or distributed generation. And then please also remember the basic idea that the statute trumps the administrative rule. If you think there's a conflict between the statute and the administrative rule, please refer to the statute. That would be the ruling authority. And then I just wanted to go through, the next part is to review some of the timelines that are in the rule. So if you look at page 16, lines 27 through 39, it gives the definitions of what a level 1 interconnection is and a level 2 interconnection. A level 1 is a facility that has a nameplate, a capacity of 10 kilowatts or less, and meets the certification requirements of Section 5 of the rule. A level 2 is a facility that has a nameplate capacity of 2 megawatts or less and meets the certification requirements of Section 5 of the rule. Obviously, level 2 applies to more types of interconnections with greater nameplate capacity than was allowed for net metering and distributed generation, which is up to 1 megawatt. However, the time frames for level 1 and level 2 interconnections are the same. And so we're going to kind of work through what the steps are in that process. First is the submission of an application. 10 days after receiving the application, the utility will provide notice that the application is complete. 15 days after that, there's a notice from the utility about the type of facility and location of the interconnection if it meets the criteria of the rule and is approved. Then the utility sends notice regarding if the inspection is required, and they send a signed interconnection agreement. That's 10 business days later. And then finally, 10 business days prior to the start of operation, the customer returns an executed interconnection agreement and provides a start date for their operation. So how does this timeline fit looking backwards from December 31 of 2017. Now, please note that this portion of this presentation, well, actually all of this presentation, is the legal analysis of the Commission's Office of General Counsel and is not necessarily the Commission's analysis itself. So if you assume that that installation is complete by December 31 of 2017, and you work backwards that 10 days before, that works out to December 14th. And remember, we're talking business days, so holidays and weekends don't count, okay? And then if you work back from there, as far as that notice of inspection agreement, so we gave 2 days, at least I put 2 days in between for the interconnection agreement to be sent out and the customer to get it back. Realize if that takes longer, that might change some things. Then moving back that 15 days prior to that when it's approved, that means you're talking about November 28th of 2017. And then going back to when the notice of application complete, that's November 2nd of 2017. And if you move back from that 10 business days, that brings you to October 19th, 2017. So based on the timelines in the interconnection rule, the application would need to be submitted by October 19th of 2017. And again, please note, and here's my legal disclaimer, so everybody pay attention. This assumes that the application is complete, the facility and interconnection point meets all the rules requirements for safety and reliability, that there's a fully executed interconnection agreement that's been received by the utility, and the net metering facility has been fully installed and meets all applicable building codes and permits. So that's working backward from there. We did also want to provide some information about what happens during those timelines and timeframes, and we felt that would be best provided by the utilities. So I believe I can turn over to to Mr. Mazel, Mr. Ruschenberg. I believe you have someone to come forward and talk about those timeframes.
We do, thank you. Tim Fulton is with Vectren, and he will be walking through the interconnection rule, the various deadlines and steps, and will provide an explanation from the utility standpoint.
And you will really have to almost eat the microphone to speak into it.
I'd like to talk about the IEC interconnection timeline as it applies to utilities and Vectren's experience. Processing interconnection applications better. The Indiana Administrative Code mandates 3 interconnection review levels that utilities must adopt. The review level is determined by nameplate capacity of the customer generation, if the system's inverter-based, and if the system meets the requirements found in Section 5. Certification requirements in Section 5 provide details on how to determine if an application qualifies for a Level 1 or Level 2 review and relies on industry standards. The IEC supplies a list of technical requirements for Level 1 and Level 2 reviews that, if met, allow a customer to interconnect to the electrical system contingent on completing the remainder of the process. Although many of the requirements are technical, I refer to these particular requirements as technical requirements, and the corresponding review is the technical review. The utility cannot impose additional technical requirements beyond those listed and shall grant contingent approval if they are met. The final approval is granted when the utility completes the bidirectional meter installation. The Level 3 review process is reserved for applications that connect to the distribution system and do not meet the requirements found in the Level 1 or Level 2 review. Nearly all interconnections processed by Vectren have been processed as a Level 1 or a Level 2 review. Vectren has processed only one Level 3 application, which was not a net meter. Because Level 3 applications seem to be the exception, I do not intend to cover the Level 3 process. The Level 1 interconnection review. Determine if an application should be processed under the Level 1 review procedure. It must meet 3 requirements. Interconnection must be inverter-based, have a nameplate capacity of 10 kilowatts or less, and meet the certification requirements of Section 5. Within the Level 1 review procedure, the IEC specifies 3 utility time limits, assuming application approval. When I mention days, I'm referring to business days. After receiving the application, the utility is allowed 10 days for application review. During this time, the utility must verify that the application was submitted at the proper review level and the application has the necessary information to process. If information is missing or the application was submitted at the incorrect level, the utility notifies the customer of the issue or issues, and the customer must resubmit the application. If the customer must resubmit the application, the 10-day timeline is reset. On the other hand, if the utility determines that the application is complete and correct, the utility notifies the customer of the same. In the next step, the IEC allows 15 days for the utility to determine if the application meets the Level 1 technical requirements found in Section 6, C through H. This is the technical review phase of the process, which primarily involves data collection and analysis. It may also include field visit to verify utility equipment. If the review finds that the proposed interconnection fails one or more of the applicable requirements, the utility notifies the customer that the application was denied. Along with the notification, the utility supplies the reasons why the application was denied. On the other hand, if the review finds the proposed interconnection meets all applicable requirements, the utility notifies the customer of contingent approval. After the customer is notified of contingent approval, the utility must send the customer an executed interconnection agreement within 10 days. This notification also reminds the customer that proof of insurance is required along with a generation start date. The process continues after the return of the interconnection agreement, proof of insurance, and start date. The process completes with the installation of a bidirectional meter and account setup. To restate the IEC utility timeline for a Level 1 review, utility is allowed 10 days for the application review, 15 days for the technical review, and 10 days to send the executed interconnection agreement to the customer. Vectren has historically processed Level 1 applications much faster than the IEC allowed timeline. Vectren may be able to continue processing applications more quickly if the number and type of applications match historical experience. At times, Vectren performs the Level 1 technical review before notifying the customer that the application is complete. This process is typically more efficient when both the application review and technical review are conducted together. A higher rate of applications can slow the process. More applications will require more resources. Also, the process can be slowed if Vectren receives larger applications than it has historically received. The Level 2 interconnection review. To determine if an application should be processed under the Level 2 review procedure, the interconnection must have a nameplate capacity of 2 megawatts or less and meet the certification requirements of Section 5. Because net metering is bounded by an upper limit of 1 megawatt, Vectren does not expect to receive any Level 2 applications over 1 megawatt. Overall, the Level 2 process is similar to the Level 1 process, but adds the option for an additional technical review because larger customer generation can have greater impacts on the T&D system and other customers. Within the Level 2 review procedure, the IEC specifies up to 4 utility time limits depending on the results of the initial technical review. After receiving the application, the utility is allowed 10 days for the application review. Although Level 2 application requirements requires more information than a Level 1 application, the basic application review is the same. After the application review is complete, the utility is allowed 15 days to perform an initial technical review. The initial technical review determines if the application meets the Level 2 requirements found in Section 7, C through O. Similar to the Level 1 technical review, this phase primarily involves data collection and analysis, but since the Level 2 process allows larger and more complex generation, the requirements cover more scenarios and larger systems. Like the Level 1 review, the initial technical review may involve a field visit to verify equipment. Depending on the results of the initial technical review, the utility proceeds down one of 4 paths as outlined by the IAC. Path 1, the initial technical review found that the customer generation meets all applicable requirements and the application can be given contingent approval. Path 2, The initial technical review found that the customer generation failed to meet one or more applicable requirements, but the utility has determined that the customer generation can be connected. Path 3. The initial technical review found that customer generation failed to meet one or more applicable requirements, but the utility thinks an additional review may allow the customer generation to be connected. In Path 4. The initial technical review found that the customer generation failed to meet one or more applicable requirements, and an additional review will not change the outcome and the application is denied. If the outcome of the initial technical review is contingent approval, which is Path 1 or Path 2, the remainder of the process is very similar to the Level 1 review. If the outcome of the initial technical review is Path 3, which is an additional review is warranted, the utility contacts the customer and offers to perform the additional review. Following the offer, the utility also must supply the customer with a good faith estimate and required modifications or both. If the customer decides to pay for the additional review, the utility has 10 days from receipt of payment to complete the review and notify the customer of the results. The results must include a cost estimate of the required modifications. After the customer notifies the utility of their intent to proceed and payment terms are agreed upon, the utility shall schedule and complete the modifications. After the modifications are complete, the utility has 5 days to notify the customer of contingent approval. The remainder of the process is very similar to the Level 1 review. If the outcome of the initial technical review is Path 4, an additional review would not allow the utility to determine if the generation can be connected. In this case, the utility notifies the customer that the application has been denied and provides an explanation for the denial. To restate the IEC timeline for Level 2 review, assuming an additional technical review is conducted. When an additional technical review is needed, this is the longest timeline for a Level 2 review. Application review, utility is allowed 10 days. Utility is allowed 15 days for the initial technical review. The utility is allowed 10 days for the additional technical review. And the utility is allowed 5 days after facility modifications are complete to send the customer an executed interconnection agreement. Historically, Vectren has processed Level 2 applications in less time than the IEC allowed timeline. For smaller Level 2 applications, Vectren typically completes the application review and the initial technical review before notifying the customer of application approval. The reason for this is the same one given for a Level 1 review: sufficiency. Vectren has found that customer generation above 100 kilowatts has more potential to affect T&D equipment as well as other customers. As a result, Vectren expects larger applications will require additional technical review and more time to process, which can affect other application processing times. Similar to the Level 1 review process, the Level 2 process can be slowed by an increase in application submittals. Items that can and have slowed the process. Based on history with processing interconnections, there are items that can and have slowed the interconnection approval process. Here are a few examples. Many of the submitted applications are missing information, have the wrong information, or were submitted at the wrong level. Vectren's Level 1 and Level 2 forms are not the same. The customer must choose the correct form based on inverter size. Vectren has received several incorrect submittals. Incomplete one lines are common. The one lines are attached to the interconnection agreement, so they must contain the proper and correct amount of information. This is more of a do-it-yourselfer issue, but happens at a regular occurrence. Missing or incorrect insurance documents occur frequently. In many cases, Vectren's insurance department will contact the insurance company directly to obtain the proper documents. Many customers are unaware that a county inspection is required. Most of the counties in Vectren service territory require an inspection of the customer's generation installation. Although the letter that accompanies the interconnection agreement notifies the customer that a local inspection may be required, we have been contacted by customers waiting on their bidirectional meter installations, only to find out that their county inspection has not been completed. Many customers submit their application long before their equipment installation is complete. In locations that require county inspections, the application process cannot be completed until the equipment installation is complete. This usually doesn't result in an upset customer, but can add a significant amount of time to the process. Customers have changed the size or other characteristics of their installation during the application process. This is more common on larger installations. Larger applications involve frequent dialogue with the customer, and in many cases, their installation may evolve as they work through their details and understand the results of a veteran study. All the comments I have.
If I might simply build on his comments, perhaps expand on them just a little bit. As you heard, Mr. Fulton works at Vectren and was able to articulate that Vectren typically processes level 1 and the smaller level 2 applications and reviews in less than the time allotted by the administrative code. That is subject, of course, to the various caveats of a complete application, so on and so on and so on, which he outlined. Let me simply add that in discussions with the members of the IEA, each of the electric utilities is in the same position. Each of them typically processes things sooner than what the IAC necessarily provides. They will continue to attempt to do that, but to the extent there's a great increase in either the number or the complexity of the applications, that may have an impact on exactly how this flows. Going back to the chairman's comment earlier, however, we recognize that the IAC is what it is, and to the extent that it takes more time than what's outlined in the IAC itself, we would suggest two things. First of all, try to get us the information sooner rather than later. Don't wait till it's right at the very end, right at the wire. The second thing is, if you are right at the wire, sort of the October 19th kind of a thing, recognize that the challenge will be that all of these things need to be correct. They need to be done in a timely fashion. And if we do, in fact, see a whole bunch of applications coming in, you may find that we are required to take this full 10 or 15, whatever period of time that's necessary. To the extent we go beyond that, that is not going to be used to somehow limit a customer's ability to net meter this year, in other words, December 31st, 2017, also then getting the grandfathering through 2047 that is provided under Senate Enrolled Act 309 or Section 40 of Title 8.
Okay, thank you for that. I did want to open this up too, so if any solar installers that are here today, that if you want to comment at all as far as what you see happening during these timeframes, that might be helpful. You know, if there's information, that'd be helpful for everybody to know here as well.
When we're doing that, Beth, just a quick question, Mr. Mosel. Could you just elaborate a little bit on what your members are doing to prepare and ramp up for an expected surge in applications? Are folks preparing for an increase in the number of applications?
They are. Is this on? They are, and frankly, they're already seeing a bit of an increase compared to kind of a historic level. The steps that they're taking at this point is simply to go through their organizations, their companies, make certain that everybody is prepared for the work that will be coming at them, that everyone is aware of the rules that are set forth by the commission, the guidelines that are set out in the statute, and the way that will play together so that everyone is prepared to do it. As you heard Mr. Fulton go through, the engineering and technical reviews have not changed from what has historically been in place under the commission's rule to what's now going to be in place as a result of the enactment of Senate Enrolled Act 309. So those will continue on as they have in the past.
And just to be clear, just to make sure we're on the same page, did I hear you say correctly, and if I did, I'm pleased to hear it, that if the installer or the customer gets their application in on time, again, preferable to sooner rather than later, but if they make the deadline and the application is complete and appropriate, and the utility does not complete it by December 31st, the onus is on the utility, not on the customer or the installer. Is that what I heard you say? That
is a true statement. I would also acknowledge that your caveat was correct. Sooner is definitely better than later. And keep in mind that what we're talking about at the moment is how a customer achieves participation in the utilities net metering program. One of two criteria that the statute sets out in order to be able to participate in the net metering program this year and then achieve the grandfathering through 2047. We have not yet talked a lot about the installation aspect of it. Certainly our industry has a view on that, but again, we would just highlight that the customer needs to have a system installed in place as that term is used in the statute.
I believe, Mr. Burkholder, if you want to talk about what happens from the solar installer's viewpoint during this timeline, that'd be helpful. Thank you.
Beth, excuse me, could I ask a,
Obviously, I yield to Commissioner Ziegner. Sorry, Mr. Burkholder.
I apologize, I should have jumped in. Mr. Fulton was describing the level 1 and level 2 application processes, and when there are issues, maybe not rising to the point where it's a rejection, is there opportunity for the applicant and the utility to dialogue a little bit to learn what's going on with the application?
Okay, that's a great question. The answer is yes. And as Mr. Fulton described, many times when there's not a problem, the dialogue, if you will, is simply, you're good to go ahead and charge forward. To the extent that there is an issue that's beginning to arise, you're describing a not uncommon practice of discussion back and forth, and many times the issue is resolved by the customer that's looking to install simply saying, well, what if I did just a little bit smaller system than what I initially envisioned? That can save cost in terms of utility upgrades, it can save time in the whole process. That's where that dialogue is so important.
No further question. If no further questions from the bench, Mr. Burkholder.
If I may, Your Honor, before Brian speaks.
He raised his hand first, and I'm not Your Honor, so I'm just Ms. Helene. That's totally fine. So, Mr. Burkholder, thank you.
Thank you. We do have a concern in utility application submission to the time that the customer receives net metering agreement. I believe most of you should be aware that with the 309 being the December 31st deadline, there will be an increase in applications across Indiana because of this deadline. We do have a concern. I do have email confirmation. On 3/21, we sent an application for a client to net metering program. And we received the net metering agreement on June 30th. That's 73 working days. And so our concern is, whose fault is that? We did not get any negative feedback from the utility at all, and we have not yet seen the increase that will be seen from here to December. What will be done? We do have another application that was submitted on June 21st, and we still do not have any feedback from the utility.
Mr. Mausel, if you want to.
I'll certainly be happy to comment. Obviously, in a setting like this, I can't comment on a specific utility issue. You know, the utility A did 1, 2, or 3, and would simply encourage you to reach back out to that utility. What I would convey to people is sitting here today and looking forward, the utilities in Indiana understand our obligations under the commission rules and under the statute. And to the extent that we cause some sort of delay, so to build on Mr. Burkholder's example, if a customer was to go ahead and submit an application, I'm going to make this extreme, on October 19th, and that first review where we're allowed 10 business days takes more than that, let's just say 15. Those extra 5 days will not be held against the customer, in terms of whether they're eligible for grandfathering under the provisions of 309. In other words, they will be grandfathered through 2047.
And Mr. Mausel, I appreciate you've got somebody from Vector here, but I think you've got somebody from all of your companies here, correct?
We do.
So would they be available afterwards if people have specific issues with that individual company?
Absolutely. Please raise them.
If you want to catch him afterwards, he'll connect you with the utility that you're having trouble with, and we'll address that issue. But please, go ahead. Yep.
The question that I would like to address is there anything that we can get in writing so that the client, not me as the installer, but the client can be assured that they're not putting out their money and having a system installed and not in the grandfathered? The timeline is not defined in the 309 bill, so we'd like that clarified and defined in print. Good.
If I could just ask you, is this helpful to have this clarify this timeline, or are you talking, help me understand what you'd like to have accommodated? Does this timeline that's up here help you and your customer get that where you need to, or are you looking, help explain what you need?
Yes, it absolutely helps. My concern for the customer is if the utility drags their feet on any part of it, will the utility take responsibility, or is that the customer's issue?
Mr. Mazel?
If I could, what I would suggest is perhaps you look on, it's page 36 of 38 in the document the IURC prepared, down at lines 31 and 32, and you were asking about a written statement from the utilities. This was filed by the IEA on behalf of our members, and what it simply says that in the event the customer achieves the two key milestones discussed above, in other words, the system is installed and the customer is participating in the net metering rule or program of that particular company, and the utility is unable to complete its inspections and upgrades prior to January 1st, the customer will be, continuing on to the next page, will be grandfathered, again, subject to the customer meeting all of the requirements. Now, keep in mind that's local zoning, permitting, homeowner associations, inspections by county or other officials. All of that stuff still needs to be done. That stuff is outside of the control of the utility. But there's a written commitment that the utility will not cause a customer to be ineligible for grandfathering this year if in fact the customer has met all of these other steps in the process.
Okay, thank you. Mr. Irwin, you had raised your hand next.
Yes, thank you. First of all, Mr. Chairman, I would like to say that joint commenters feel a little disadvantaged at the moment. We're 45 minutes into this technical conference, and it's been pretty much absorbed by the Indiana Energy Association, one of their utilities, discussing things in which we believe could have been submitted in writing. We provided examples, just a few examples of some issues that are being experienced in the field. The Indiana Energy Association and their member utilities did not choose to provide that in writing. Rather, they took a half an hour of today's technical conference to articulate what we believe could have been articulated in written comments, such as we filed. And so I will reserve our right to respond since this is being transcribed. I'll reserve our right to discuss with our colleagues and our members and other solar installers with respect to their comments. Secondly, I would like to, with all due respect to Mr. Mazel, the idea of Vectren getting all applications on within time. Let me be clear, that is his opinion. That is not a fact. Is this a case in which we're going to conduct discovery to substantiate some of these claims being made by the Indiana Energy Association and their member utilities today? I think that's critical. Secondly, and with all due respect, Mr. Chairman, I don't think we came here today looking to kibitz with the utilities over specific issues that installers may be having with one utility or another. I think we came here today hoping that the commission would get an understanding that there are issues across the state. There is a huge interest right now in solar. We have a controversial bill that is affecting a lot of folks. It's emotional. We have 5 utilities who do things very, very differently, very inconsistent. And it was our hope that we would come here today and the commission would provide some protection for customers, for these solar installers, some consistency statewide, rather than providing a forum to discuss with a particular utility about a problem a solar installer may have. And lastly, I'm not clear what this timeline is that is on the wall, but I can state unequivocally that it is a position of joint commenters that from our perspective and in our opinion, that if a customer and a solar installer have done everything on their end that is required of them with respect to sizing a system, pricing a system, planning a system, obtaining financing, signing contracts, putting down payments, making a financial commitment, and submitting that paperwork to the utility by December 31st, 2017, if a customer has done everything that is required of them on their end, including financial skin in the game, by December 31st, 2017, they have a postmarked envelope of their submission of an interconnection application to the utility, then they should be grandfathered under Senate Bill 309. That is our position, and so we're not clear on precisely what this timeline is suggesting.
Okay, well, a couple things, Mr. Olson. First of all, points all well taken. You came before the commission informally with the CAC about a month and a half to maybe 2 months ago and expressed these concerns about confusion and wanted clarity. We're here because of your request, so.
I appreciate that, and I
Okay,
understand
well, I
that.
didn't hear that in your comments, so I just want you to know that's why we're here. And so we're trying to set the table here. The timeline up there was Ms. Helene's attempt, at least with her legal experience, sort of begin the conversation. We've just started. We welcome your questions. We welcome your input. So give us a chance to kind of flush this out a little bit. No conclusions have been reached. With that, if you continue, did you have a question, Ms.
I have a
Weber?
question. Mr. Olson, did you say kibitz?
I did say kibitz. Isn't that strange?
What does that word mean? And how do you spell it?
Kibitz is a word I heard all the time growing up on the Upper West Side of Manhattan about having a casual conversation.
Okay.
No idea how to spell it.
I kind of enjoyed the kibitz from the installer, and actually it leads to some questions I have that I think relate to what you said, and it's actually directed to Mr. Mossel. So, with respect to this timeline, maybe you could help me understand when there's like a physical installation. I know that's a question concerning where people have raised is installation, but if there's a physical installation, when does that occur? I understand that, or maybe someone from a utility can help me. I understand there's a submission of an application, there's some of these paperwork things that occur, but when does a physical installation occur in this process? Does someone know the answer? Mr. Mossel, do you know, by any chance? Oh, Mr. Ruschenberg, that's fine too.
That's fine. Thank you, Commissioner. Yes, and in our written comments, which we submitted, we talk a little bit about the two requirements in Senate Enrolled Act 309. One of them is the installed part. The other part is the participating in the tariff, net metering tariff. So the way installed, we look at the dictionary as to how installed is defined. And this is what we mean by this is when the net metering facility needs to be installed no later than December 31 of 2017 in order to qualify for the grandfathering. So in terms of, if you look at the Oxford English Dictionary, defines installed as, quote, to place in position or connect for service or use, end quote. So in our view, as used in Senate Enrolled Act 309, the customer's net metering equipment must be in place and ready to be operated, and such installation must be consistent with an interconnection agreement, interconnection application submitted to and approved by the utility pursuant to the interconnection rules of the Commission, as well as consistent with Senate Enrolled Act 309, the net metering rules, and the net metering tariff. So in other words, it needs to be in place and operational.
So at what point in this process does that actually occur? If I want to, install some solar panels and I submit an application to a utility, when do I physically do that? I've never done it before, so I don't know. Maybe someone else can help me with that. So do you need to get an approved application from the utility before you install something? Curious.
From the utility's perspective, the answer would be no. You do not need to have the approved application. You could do it totally the other direction should you choose as a customer, and it's a customer decision. You could frankly build the entire system, then file the application, so on and so on and so on. I'm going to suggest that may not be the most advisable thing because of the technical requirements that are placed on the utility to assure that this system on a customer's home or business will in fact operate in a way that assures that it's safe, that it does not impact the reliability of the system or the power quality of the the other customers in that particular area.
Okay, so if I might be just missing some nuance here from discussion, but it sounds to me that what the utilities are saying is if you get an application, you submit it, and ultimately is approved, it's considered installed. Is that correct?
I think the application itself is what we would look at and say that is going to lead to participating. So
Okay.
one of the two. Installed is that there has to physically be all of the stuff that's necessary to create the net metering facility, whether that's the generation device, the solar panel, for example, inverters, all of the wiring that needs to happen. That's what's going to create the installed aspect to meet the statute. participation is going through the process that's outlined above through the Commission's administrative rules.
So then back to Mr. Burkholder's issue is that this applications have been submitted. He hasn't heard from some installers or developers. They haven't heard anything, so they can't even get to participating yet, let alone installed. Is that correct?
They could install separately, so
Okay.
they might be able to get there. The commitment from the utilities is that recognizing the deadlines that were set by 309, if he runs into that situation in the future, and the utility is not able to accomplish what we're allowed to do under the rule within the timeframes given to us, we will not hold that time against the customer in terms of saying you're participating. Just to make this extreme, on the other hand, if a customer submits an application on December 31st, they will not be able to participate because they will not have achieved, walking through the entire process.
Okay, so one more clarifying question, and I think I can yield the floor. So I think what you're saying is that in that instance, let's say with one of Mr. Burkholder's clients or installers, they are not participating yet, and they certainly aren't installed yet. So what they would have to do, so let's say they've gone through this timeline, they can't be considered participating because maybe you've had so many applications, you can't get maybe a response back by the date of December 31st.
Okay.
So you would grandfather them in on the portion of participating, but installation is a separate issue. But I think you might have said it might be unwise for them to go ahead and install without having the participating portion confirmed. Is that right?
To the extent that a customer is looking at something that is outside of the commission rules, if you look at the commission rules, it's very explicit about if the equipment you're using meets IEEE standards, the Institute for Electronic and Electrical Engineers, if it meets the UL, the Underwriter Laboratories certifications, if it meets those kinds of things, if you're buying an inverter, for example, it meets those standards, for the level 1 that is fairly common in a residential area, even the smaller level 2s, if you're a little bigger home, that will undoubtedly meet the technical requirements that are necessary going forward.
Thank you, that's helpful.
Mr. Burkholder, can I ask a question, kind of the same question, just a little differently? You get to the end of this, you get the customer signs and returns the interconnection, or the notice of the inspection, the agreement has been met, and they come to you as the installer and they say, okay, we're ready to install. How many days do you need to install a 5 kW system on a house?
1.
Thank you.
It does not take us very long to do a system, but the complaint overall is that March 21st, application was sent in. Within a couple weeks, the system was installed. We're talking 3-4 weeks, system was installed. So it's been sitting there 6 weeks, waiting on the utility for the net metering agreements and to change out the meter so we can even activate the system. So if that happens towards the end of the year, who's at fault? That's the question that we need to make totally clear for all homeowners across Indiana.
And if I can just interpret what I think the IEA comments say, they say that in the event that you got your application approved or through this, the last section before installation complete, and your system is installed but for the meter, or but for some disconnect switch, for example, that would not limit you. If you were at that position by December 31st, your customer would qualify. Is that a fair reading of your comments?
With one caveat, and that's that the disconnect switch, depending on which utility we're talking about, the requirements, the demands of their system, that may be a necessary component. To your point, though, if it's a matter of the meter being changed out, that would be on the utility. If we don't get within that, again, just looking at the schedule Ms. Celine put up on the screen, if we're not able to do that between December 14th and December 31st, but it actually goes into January somewhere, that will not be held against the customer. They will be considered to have met the December 31st deadline. They will be grandfathered till 2047.
Thank you.
And I believe we had a hand raised by Laura Arnold first, and then Jennifer Washburn. Ms. Arnold, did you want to?
I'm sorry if I'm still not understanding clearly, but the interconnection rule does not contemplate that the utility has a right and a time frame to request that the customer change the meter. So I'm still not understanding what Mr. Massel is saying, because what the problem has been, if we're going to name names, Duke Energy has imposed saying that there's an internal regulation or rule that is not in writing and is not in the approved tariff for Duke Energy's interconnection that says that of which they have conveyed that they want 14 business days from the time that all of the equipment is installed and waiting to be energized, and then they want to add an additional 14 business days. So I also don't understand the Vectren comment that there isn't, I'm not seeing the reference that says that you get in that time frame to install a new meter. That's not part of what is in the interconnection rule. So we would also like to indicate that what we need is a clear definition of installation, which I'm still not sure I'm exactly getting from the comments made by the Indiana Energy Association. But we do believe that it should be when the customer and their installer has completed their work, and then we don't care what else the utility thinks they have to do before they energize the system. So we have a number of other terms here that are not mentioned in the statute, and they're not mentioned either in the net metering rule or in the interconnection rule that really need definition and clarification.
Okay, thank you. And then Jennifer, you had raised your hand, and I do want to point out we have yet to get to the topics that we were here to discuss. We're still talking about, just generally speaking, what happens during the interconnection rule timeline. So we still have some additional topics to talk through, but Ms. Washburn.
Thank you. Jennifer Washburn, Counsel with Citizens Action Coalition. I just wanted to highlight on page 33, starting at line 25, going through onto the next page, page 34 to line 9. We're just hearing a lot from installers and customers across the state about delays with the interconnection process. And although I sincerely appreciate the representations made by the IEA that they're going to honor and take responsibility for the delays that are happening, how will that be documented? How will disputes be resolved? As we saw in cause number 44344, it's a very complicated process. We're hearing about applications being lost, checks being lost. At what point, if a system size is changed, does that kick the entire timeline back over again? There are a lot of things that could be resolved by having a more simple interpretation of the statute, which we would argue should be when the customer submits their application. And at that point, that's an active net metering application, and it would be a lot clearer, a lot easier, and then at that point, the commission wouldn't have to be mediating many disputes that we would anticipate just from the sheer volume of increased activity that we're hearing and the sheer volume of increased disputes that we're hearing with regard to delays in the field.
Thank you. Oh, yes, sorry. Ms. Wheeler.
My follow-up question was regarding some of the commissioner and staff comments about installs, which I think is the first topic, which I also am anxious to get to because the clients that we represent are very interested in the application of these sub-issues that you've listed on the agenda. Would it be appropriate for me to ask a follow-up question about that first install topic at this time?
Actually, if you give me about 2 more minutes, I'd like to get through the rest of the interconnection portion. We had a couple other questions about the interconnection rule itself.
Sure.
And then we'll get to the actual, the topics that were listed on the other topics that were listed on the agenda. So one of the other questions that we had that came in regarding the interconnection rule was regarding the fees and charges. And this was by the the Carmel Green Initiative, Citizens Action Coalition, Sierra Club, Hoosier Energy Council, that coalition, and Indiana Distributed Generation, I think I got them all, that submitted joint comments as far as if we anticipated any changes. The statute does allow the commission to do a rulemaking that could possibly change the fees and charges. And I would say, and because it's my office that does the rulemaking, we are not anticipating any changes to that. Okay. So unless we have any other questions, we'll actually now get to and I think probably the key one. There's the first three topics that we're going to discuss are kind of interrelated and key, but we'll get first to the meaning of that word installs. This was raised in basically everyone's comments to one way in one term or another, and we definitely appreciate that. And what was raised was really the practical considerations for those involved in net metering is what has to be installed by when in order to meet the December 31 grandfather deadline. And I know that everyone has asked this question, and I'm acknowledging that. And Indiana Energy Association addressed this issue in their comments. So I would like Mr. Mazel to address that briefly, and then we'll go back to so if after their comments, if there's additional questions or concerns or comments, then we'll go back through. Mr. Mazel.
Ms. Lean, I'll do it. We mentioned in our comments, thank you, by the way.
Is your mic on? You don't sound
Yes,
anywhere near loud enough.
I got to get, there we go. As we mentioned in our comments, we look simply to the definition of the word installs or installed, which is what is used in Senate Rolled Act 309, that the net metering equipment needs to be installed by December 31. So the definition, again, is to place in position or connect for service or use. So it needs to be in place and ready to be operated. That's what installed means. That's the definition of the word used in the statute.
So that is IA's, the utilities viewpoint of installs. Other comments and questions? Okay, now everybody said that they wanted to talk about this. So, Mr. Harden from Johnson Mello.
Thank you. Really appreciate everyone being here today, and from both sides, and looking forward to clarity on this topic. In regards to a system being installed, we're talking about two issues here. One, going through the interconnection application process and getting that complete, and talking from an installer's point of view, such as ours, where our average project size is more along the 1 to 2 megawatt range of an installation. Our clients are not inclined to install a system prior to having an interconnection application in place, which obviously with that size system puts us under construction restraints with the utility, obviously receiving an increased amount of applications, which could delay that process. I guess my question is does that mean we get an extension past January 1 for completion of installation, being as in the time frame for the application process, we also have to get city or county inspection completed prior to the utility coming out and installing the bidirectional meter for a complete system?
Did you want to respond, Mr. Mazel or Mr. Ruschenberg?
So just to be clear, there's kind of two issues here that we're sort of mixing together. The interconnection rule with the timeline that you see on the screen is more, the Energy Association, look at that as an issue, that's more tied to the participating aspect of this. So we'll talk about that in just a moment when that item comes up on the agenda. As far as installation, as Mr. Ruschenberg pointed out, yes, it does require that the physical equipment be there. The reason that we have looked at that is because of Senate Rolled Act 309, which is now the law. It's been incorporated into the code here in the state of Indiana. To the extent that the law requires us to look at it and say the stuff has to be there, it has to be operational, it has to be ready to go, then that's kind of the direction that we were headed. To the extent that your clients would prefer to move through the application and interconnection process before beginning construction, that is, of course, their option. As we point out, the challenge is to have everything done, both installed and the ability to participate in the system by the end of this year. The installed part, though, would need to be done by the end of this year. We're not looking to say, gosh, we can go into next year somehow. The one piece to that you did touch on, and I think I should perhaps revisit, to the extent that the issue is that the utility has not had a chance to get out there inside of that 10-day period when we're allowed to do an inspection or to move through things. And many times the inspection's actually done by the person who'll be installing the meter. That will not be held against the customer in terms of their ability to participate in the net metering program and hence participate in the grandfathering through 2047. I should also note that, and I know that you do the larger systems, to the extent it's anything larger than 1 megawatt, it is not eligible for net metering. It is only 1 megawatt or less. And then there's a second caveat, but I know in the case of your customers, many times that doesn't apply.
Other questions or comments regarding the term installs? Ms. Wheeler?
Thank you. I just want to take a step back for a moment and talk a minute about this install issue, because if you look at the interconnection rules, I promulgated those rules with many of the people that are still on staff at the commission, and the primary driver of those rules when they were promulgated was safety. And when you look at the different levels and you look at I don't have the rules in front of me, but when you look at an inverter rating from IEEE or Underwriter Laboratories, that's the maximum that inverter can hold. When you are looking at a solar system, due to weather, due to the direction of the solar panels, due to a lot of different reasons, the amount of electricity that's actually flowing through that meter can vary a great deal, especially at night. And the reason I point that out is I'm a little troubled, frankly, by this idea that the system has to be completely installed and never can change in order for the grandfathering to apply. Because my understanding from the customers that we represent, who are large industrial customers who are doing, and schools who are doing these larger systems, not residential systems that are much more simple to install and straightforward, as others have pointed out, is that what I'm hearing is it is not uncommon to need to make tweaks. So when I was thinking about what does install mean, I was thinking about whether the system could be energized. Because from a point of view of a utility, from a safety and reliability perspective, what they're concerned with, or maybe should be concerned with, is how much power is coming through that inverter so that they don't create system instability and safety concerns. How many panels they have, or whether a particular customer had a panel that was dead and didn't work as it should, or needed to be moved or performed at a better rating than was expected in their original plans, is not really something I think that the utility should be able to say, no, you're not installed because you made some small change to your system that had no impact on what level of interconnection review you have and had no impact that exceeded inverter rating from a technical perspective. So my point is that I hope the commission would take into consideration the fact that these systems do change, they might change, and that is not something that necessarily should affect, at the end of the day, whether a customer is grandfathered in for the purposes of the net metering statute. And to define installation as a single point in time with nothing can ever change, if you're changing a level of interconnection review, if you're changing an inverter that you need, that to me is something different. But when you're just tweaking a system to try to meet the needs of a customer and you're not really creating any system or safety impact on the other side for the utility, I just question why we would need to define that so narrowly.
There was who are you pointing to, Ryan? Oh, Mr. Olson, so sorry.
Yeah, thank you. Again, we would ask, how would install be documented? Who documents that? Where do they keep it? How do they prove it? What if there are disputes? And so again, we appreciate the statement that, oh, those folks will be grandfathered. But again, how are customers assured of that? Where's the documentation to show that? Where is the consistency statewide between the 5 utilities that gives installers and customers certainty, understanding what the rules of the game are, and where is the documentation, the process to ensure that utilities won't drag their feet, as Mr. Burkholder has discussed with one of his customers that he's dealing with. So again, the big thing for installs is, what if there are disputes? How does that get documented when something is installed? And again, appreciate the idea that those folks will be grandfathered. But again, where's that piece of paper that an installer can show somebody that says that, whether they're in Elkhart, New Albany, Evansville, or Terre Haute?
That's correct. And I know, Mr. Ruschenberg, you had your hand raised, so you'll be next up. But for our court reporters, they need to actually change out the paper. And so we're going to take a 10-minute break. And so if you want to stand up and move around a little bit, that's fine, but we will start back up again in 10 minutes. Thank you.
Talked a lot about the interconnection rule and the missing of dates and taking months or weeks or whatever it may be. I do want to point out that the rule itself does allow an avenue for installers, customers to address this, and it's on page 26 of 38, line 10. It's 170 IAC 4-4.3-12, which is the customer. Oh, I'm sorry, 170 IAC 4-4.3-12. That's the customer complaint section. So there's an avenue in rule that has been in rule, that remains in the rule, to allow customers to file a complaint if a utility has blown a deadline in that interconnection rule. So there is an avenue already in existence that has been in existence for years.
Mr. Miles, sorry to interrupt, but on that point, and maybe your expert witness from Vectren can address this, but I think Mr. Olson raised some points about how does one document that so that complaint can be more effectively submitted to the commission, and how would the evidence be gathered to formulate that complaint?
Well, I can give my opinion on it, or Mark. However, but I think we have, he's already presented some in terms of emails, just like any other evidence, whether it's written testimony or emails, any kind of documentation, just like any other evidence would be gathered in any other proceeding.
We do envision that as the avenue here at the commission. That's why Kenya's here. She heads our Consumer Affairs Division. We do envision that being the adjudication process for these complaints. We hope they're limited, but I do think it is. There's been a lot of offers of goodwill in terms of the utilities absorbing any burdens that the utilities are responsible for, but it will be important to kind of figure out how to document that so customers and installers can have some assurance that they're going to be able to submit that to us, if not to you all. Hopefully they'll be able to address it with the utility directly, but if they need to come to us, we will want to figure out how best to document that so they can do that in good faith.
Well, like you, we would certainly encourage any installer, any customer to work directly with the utility to try and resolve issues as quickly as possible. Realistically, the documents we're talking about, as Mr. Ruschenberg points out, are emails, which means that they will be in the customer's possession or the installer if the customer is having that individual file the paperwork, as well as the utility. We should both have the same emails.
Mr. Olson, do you have a comment on that? Because that is something we want to
Well,
be sensitive here because we're going to hear those complaints and we want to make sure that we can adjudicate them appropriately.
Yeah, I guess I would have two comments. Number one, would that timeline stop when a complaint is filed? Would be first. And secondly, I appreciate your desire or hope rather that the complaints are limited. And I would suggest, rather we would suggest that complaints could be limited if the idea that an application being submitted and timestamped by a customer to a utility represented that December 31st, 2017 timeline, because if that application is incomplete or incorrect or there's errors or omissions, that's the fault of the customer. And so there any problems there would fall on the customer versus a timeline like that, which is open to delays, and other methods by the utilities or others that may cause a delay in that timeline. If you want to limit the complaints and put some onus and some responsibility on customers, then the December 31st, 2017 timeline with respect to an application being submitted by a customer would, without question, limit the number of complaints.
So just to be clear, do you even agree that the rule does sort of lay out the timeline that's before us? And what you're saying is, from a practical standpoint, to eliminate complaints, don't follow the rule, but use the December 31st deadline just to allay any doubts? Is that what, I'm just trying to understand your point.
The point is, a December 31st, 2017 timeline brings certainty to customers, consistency statewide, will significantly limit the amount of complaints that the commission and the utilities will have to deal with. And achieve what you hope by having these kind of what are arbitrary timelines from our perspective anyway, in terms of applications submitted 10 business days. Every one of those are open to some sort of delay for one reason or another, and can be extended as the veteran individual articulated for one reason or another. So delays will be caused not by the customer but by other factors. And there are going to be a lot of folks out there under those timelines that are going to be pretty unhappy come the end of the year. So under that timeline, I think there will be an avalanche of complaints and unhappy folks. And so I think that's what we're hoping to achieve out of this process, is to at least have the commission bring some protection and assurance to customers that this is how the playing field is going to look moving forward. We'll give you till December 31st to get your application in. If you got something wrong on there, that's your fault. Does not give the utilities or others an opportunity to bring delay to that process, and that brings certainty for customers, which they deserve, with a bill that was controversial and it's right. But I think the spirit of the bill was, hey, everybody's got till the end of the year to get into the game. And so I think with the bill that became effective July 1st and December 31st, that's a pretty tight timeline. And customers and consumers are looking for a friend right now.
So do you agree that this is the timeline, though, that's stipulated by the commission's rule? You're just saying it should be waived for the following reasons that you just stated?
I would agree that, yes, I would agree with that.
Okay. I'm just trying to understand your point. Thank you.
But I would also note that installs, participating in other things within Senate Bill 309 are undefined and somewhat vague.
Just to make sure, one question for clarification. If my understanding is correctly from Mr. Mossel and the IEA, if you get your application submitted before December 31st, regardless of what happens and regardless of when they're able to finally approve it, you are grandfathered in. Is that your understanding? Yeah, yes. I'm sorry, I meant before December 31st. If you submit that application, you're grandfathered in for that date, the December 31st date. Is that your understanding, what they're saying? Do you want me to repeat that? Yeah.
Yeah.
So my understanding is if you submit an application and for whatever happens during the timeline before December 31st deadline, as long as your application is submitted before December 31st, you're grandfathered in. Is that your understanding?
Yes.
Okay. Is that response from the utilities or that what the utility is saying, how they intend to handle it. Does that satisfy you? Because I know you've raised some other concerns about consumer complaints.
No.
So, okay.
No, that does not satisfy me because what we frequently hear from the utilities at 200 West Washington Street or at PNC Center does not match what folks like this are hearing from their utility contacts out in the field. And so, no, that does not bring us any comfort at all to hear what we're hearing today necessarily. We're looking to the commission. I think customers are looking to the commission to provide that certainty, that protection, and that guidance. And we would love to limit the amount of complaints that are filed. And again, I'll reiterate that we believe that December 31st application deadline, assuming that application is approved, that brings the best protections and certainty for customers. Because if there's a mistake on that application, then that responsibility falls on the customer. And again, I'll point out too that we're looking at wintertime too with weather. Huge weather complications. What if this is 1978 or 2004 again, where we get enormous amounts of snow and things are shut down? We came here in good faith, as we told you, Mr. Chair, when we first met you, that we have concerns about what it's going to look like out there, and we'd like to see some sort of process put in place that brings some certainty and protection to customers.
I think I might be missing something, so I'm going to ask one more question, and you can help me understand, Mr. Olson. So even if you submit your application before the December 31st, 2017 deadline, and you're considered grandfathered in by the utilities, that's not enough certainty? I think I might be missing something in your argument or your concern.
I guess I'm not understanding your question.
Mr. Harden?
I apologize. There's the second part of this, that approved application and a complete and installed system to get the net metering for 30 years.
Are you talking about the installation piece?
Correct.
Yes, I understand. Yes, I'm with you on that.
So what he's saying is that if the application is in and complete, submitted by October 19th and approved by December 31st, yes, that's approved. But the other part of this is the installation portion, where the system has to be, as defined, all net metering equipment installed and ready for use.
Okay, that's what I'm missing. So you're saying that if there's a consumer complaint at any point in this process, does it toll the installation deadline? Is that
correct?
Got it. Okay, that's what I was missing. Okay.
And if I may make somewhat of a suggestion into the standard of this and making it more black and white for customers, installers, and utilities to understand. Some years ago, when IP&L introduced the 150 megawatt feed-in tariff projects, customers could submit an application. They were received in order, and if approved in order by a certain deadline, then there was no time limit on installation for that. Our company owns 9 of those sites today. That's still underneath that feed-in tariff. And as it stands today, under that feed-in tariff, there's one project that's out there that's approved to be installed. It's not, but it could still be installed under that feed-in tariff. There was not a limit on the installation to that. And that would give clarity to everybody that if we were to submit an application and submit a design project that meets interconnection, then customers can make this investment and not have to worry about installation date where, as stated before, coming up at the end of a year where Mother Nature can be an aspect that is out of our control to install these projects. Again, we have a significant customer base that is going to make an investment on systems that are 1 megawatt. These are $1 million investments that they're not going to move ahead on until we have improved interconnection application through the utility. That's going to, if the interconnection application process is delayed for any reasons, that's going to make the installation portion of this more difficult for everybody's customers in this room.
So with respect to installation, and I think what you're maybe arguing for, if I could maybe repeat what I think you're saying, is that there has to be, you think there shouldn't be sort of a deadline on installation as long as you have an order, for example. You have a facility that still isn't installed. Is that right? So you think there shouldn't be a deadline? Because I think we're limited by the statute. Is that correct?
That's correct. That's what I'm saying, is that if we could have a process where customers can have a viable application that's been properly designed per IEEE 1547, using products that are all properly UL listed, if that's an approved application, then an extension to the installation portion of this would bring clarity for everyone.
Do you think the statute allows for an extension of the installation portion?
No, ma'am.
Okay.
Okay, the next person that's up to comment is Bob Johnson.
And thank you, Your Honors, and I will be frank, many of the points I had hoped to raise were just raised. But let me speak to you as the attorney for a customer group that appeared before this commission, cause number 44344, that was the Morton Solar complaint. And some of you remember that, I know. But that was the last time a group of customers, I believe, were directly in front of this commission and were disadvantaged by the commission's interconnection rules or their. In any event, what I think is necessary for customers and what I hope the commission would consider is giving a bright line certainty to the customers who are out in Indiana today, ready to install, thinking about installing, and ready to make a financial commitment, but who are uncertain of whether that capital is going to be at risk because of the implementation process here. So I would urge you from that perspective that two things are vitally important. One, there is a bright line for customers as to what has to be done by what date. Certainly, the definition of installs is problematic. I suspect the definition of installs may be litigated down the road because it is a gray, to say the least, in some perspective. Customers need to know what they need to do by X date. Secondly, they need to know what relief is available from this commission in case that does not happen by X date. I expect and appreciate the process of the Consumer Affairs Division, but I suggest that the commission may want to elevate this and understand that complaints that come before it with respect to the implementation of SEA 309 are going to be highly technical, highly complex, and in need of prompt resolution. Morton Solar case took a number of months to resolve. That kind of situation here probably kills customer participation in the process. So I encourage you to put some definition through the ability that you have, whether it be a GAO or however you interpret guidance, so that customers know what they have to do by December 31st to take advantage of this statute, and so that they know if there is a disagreement, that they've got a process that is prompt and efficient to resolving those. Thank you.
Appreciate that, Bob. Just appreciating that there's some debate about installation, but this timeline, October 19th, you don't think that gives some additional clarity and direction in terms of when you have to have your application in?
Your Honor, if October 19th was the correct date, I would agree that it gives clarity. I don't believe it's necessarily the correct date because it all is triggered upon installation and what a customer has to do to install. Is that defined by the IEA member, or is that defined by the customer taking certain cognitive objective steps?
Okay, thank you.
And the next person we had up to comment is Daryl Boggs.
My name is Daryl Boggs, D-A-R-R-E-L-L-B-O-G-G-E-S-S. I'm speaking to you as a solar owner for 7 years with a pleasantly, satisfactorily operating, interconnected, net metered solar system on my home. But it's 7 years old. My panels they're rated for 240 watts. I can now buy 330 watt panels for less than half what I paid 7 years ago. I'm expecting to upgrade my system, and after being here for an hour today, I'm expecting to have mine installed before October, just in case. But my comment to you is, as a retired industrial process engineer, I'm looking at this from a process flow point of view. We have a fairly clearly defined paper process. I think most people understand that. I think most of us recognize it can have discontinuities. There can be papers misplaced. Things happen. But there's a parallel, or could be in series, physical process, the installation. As the owner, they have to arrange financing. They sign a contract with the company. They pay a deposit. The company orders the materials. The materials arrive. The job gets on their schedule. They complete most residential jobs, weather permitting, in 1 or 2 or 3 days. So a typical solar company may have 1 crew. On a clear day in the summer, a clear week, they might complete 3 or 4 or 5 jobs in a week. I don't think that's likely in November and December. If history serves as a guide, you can expect some snow. Cloudy days, rain, sleet. I drove through rain and sleet today to get here in July. So it happens. My suggestion to provide some clarity on the install issue, which is easily defined. The materials are in place. They're connected. They're capable of operating. But who knows that? How is it documented? When? And to whom? I would suggest, for clarity, if there were an expectation for the solar company, the installer, who has knowledge of what's happening from boots on the roof that day, they have some process to document to the utility company that the installation was complete at 2 o'clock this afternoon, for the record or the future reference as evidence. This is a stake in the ground. It's finished. That's one essential element in the process, which I think is not clearly identified as who is responsible to report it, when, and to whom. I think that would help.
Thank you. Are there, and I know some of these issues are interrelated, especially when we talk about participating, and then it's already been brought up about the impact of repair, replacement, or upgrading the net metering facility. But in order of our agenda, let's go to participating. As far as what does it mean when for a customer is participating? And we had comments on that from Bose, McKinney, and Evans, and as well as what I'll call the joint commenters group. And if either of them would like to provide some comment first about what they think that should be, and then we'll go to the Indiana Energy Association.
I won't take up any more of the
Mr.
commission's.
Olson?
Yeah, I won't take up any more of the commission's time, and I'll reiterate our position that customers participating from our perspective when they have submitted their application and done everything that they can on there.
Ms. Wheeler, did you want to speak?
I would agree with Mr. Olson that participation ought to be triggered by applications. That makes sense. It's a clear, bright line, separate from the install issue.
Okay. Mr. Mausel or Mr. Ruschenberg?
Thank you. I know it was discussed a lot so far and was touched upon earlier about it in terms of clear, bright line rules. And in the bill, the law, Senate Enrolled Act 309, it talks about the installation needing to be done by December 31 of 2017, and also the participating in. So those are the two key milestones that must be achieved by that December 31, 2017 date. Customer, in our view, will be participating in the net metering program, the net metering tariff, if it has installed the net metering equipment, as we've already discussed, and if it's consistent with the interconnection rules. The customer has, A, submitted to the utility a complete application for interconnection. 2, received from the utility notice that its application is complete. 3, received notice from utility that the application meets the required interconnection criteria outlined in the rule. 4, received from the utility an executable interconnection agreement. And 5, returned to the utility an executed interconnection agreement. As we know from the timeline that was posted earlier, there's 45 days, 45 business days built into the interconnection rule. With regards to that, Senate Rolled Act 309 also addresses the interconnection rule and the Commission's ability with regards to that. There's actually it's on page 8 of 38, beginning at line 26, all the way down to line 43. It says that after June the 30th of 2017, the Commission's rules and standards as set forth in the net metering rule and also the interconnection rule remain in effect and apply to net metering under both the net metering tariff and then also the distributed generation tariff, which would begin the earlier of the 1.5% summer peak load cap or the July 1 of 2022. Point being is that the timeline here is pretty much set in stone under, not only has it been in effect for 11 years since 2006, it's also pretty much set in stone by Senate Rolled Act 309 in terms of remaining in effect and not being able to be changed for purposes of the interconnection and the timeline that we're talking about here. So that's our response. Again, the 2 key milestones, the installed by December 31 and also the participating in the tariff. And I listed those 5 steps that we think participating in requires from our perspective.
Mr. Olson?
Yeah, I just wanted to respond to Mr. Ruschenberg as far as 45 days set in stone. I would note what is missing from the timeline up there is that those are within 10 business days, within 15 business days, within 10 business days. That would be the maximum. So that is not a requirement of the rule necessarily as far as there's 45 days set in stone, there's your timeline. That's a maximum. So wanted to point that out.
And I agree with that, by the way. That is the maximum.
So somebody could have an application approved, submitting it well after October 19th and still be within Commission rules.
Okay, thank you. Ms. Wheeler?
I apologize. I still feel like I'm hearing 2 different things about what is grandfathered in here, one from IEA's comments and one following the line of reasoning from Commissioner Weber. And I apologize, it's late in the day, it's a very warm room, but I am not feeling like I'm hearing the same thing. What I thought Commissioner Weber said was if you submit your application prior to December 31st, you're grandfathered in, which I realize is a separate issue from installation. That didn't seem to be reflected to me either in earlier comments prior to break or in the comments from Tim just now. So could we maybe revisit that, please?
Let me jump in if you don't mind, simply because the commission may have to make a decision on this, and I don't want to leave the commissioner in a position where she's trying to opine on something she may actually have to rule on at some point in time. What we, the IEA, are suggesting to you is how we interpret and understand Senate Rolled Act 309, the law of Indiana, and the interconnection rule, and the interplay between those two. Senate Bill 309 requires 2 things in order to be grandfathered at the end of this year for a 30-year period. Those 2 things are the system has to be installed and the customer has to be participating in the net metering program of that particular utility. To meet the second of those, the participating in, you have to go through the application process, the complete process, including and ultimately resulting in the utility sending you an interconnection agreement, you're signing it and sending it back. At that point, from a utility standpoint, now I don't know what the commission may do with this. From a utility standpoint, we believe that you are now participating because at any point in that process, you may decide not to sign the interconnection agreement for some reason. I don't know what it might be. That's fair. You still are not participating in the program. So hence, we walk through the entire process. The General Assembly envisioned that. The General Assembly, specifically as they moved that law forward, revised the date for this cutoff when you're grandfathered for 30 years from behind us at this point in time to December 31st to allow for some opportunity to people complete systems that are already in place and underway. And so what we're describing is exactly how we view what the General Assembly has set before us in the laws. Now, I should also mention, this does not mean, if you miss December 31st this year, it does not mean you're not eligible for net metering. The net metering program continues until 2022. The thing that changes is the length of time that you're grandfathered. But the pricing regime set out in net metering will continue into next year. And if the numbers that were discussed among the members of the General Assembly are accurate, that is sufficient time for a customer to recover the cost of their investment in a system.
Thank you for that clarification, Mr. Mussel.
Mr. Harden?
Again, thank you for the clarification that you gave there, but I do want to comment in regards to not completing the system, as he stated, and still getting a net metering benefit, which is capped at 15 years instead of 30. And in the cases of several of our clients, that would be a loss of revenue investment over the term of building their system or investing in their system in the millions of dollars, the difference between net metering for 30 years versus 15 years. So again, clarity on this system would be very helpful for everyone if it's in regards to application being in and submitted and approved, and if a system can be installed. Again, it protects the customers from who are investing and making decisions through their budgeting process that they haven't been able to venture down to this point because the Senate Bill 309 has created so much unclarity in the market that folks now that are wanting, or customers now that are wanting to make this investment, we're creating a backlog at the end of the year to try to get these in and installed, and we have to go down, can't be, in my opinion, for the protection of customers, can't be in a parallel path of installing a system prior to having an application approved. Even at systems that are rated 10 kW, 15 kW, the utility grid has to be evaluated in every case, and there could be significant upgrades that are required by the utility for proper protection of a system that could ultimately detour a customer from making the investment of installing a solar system. So any level 2 solar installation absolutely should not be installed prior to an application being submitted, reviewed, and approved by the utility. So again, clarity on that timeline and an approval process for the application portion would help everyone tremendously.
Thank you. Mr. Burkholder, and then we really do need to get to the next one because I know that will answer, hopefully, at least have some dialogue on some of the questions that Ms. Wheeler raised earlier. Mr. Burkholder.
Thanks. I would like to have, let me give you an example of all the customers out in Indiana. Everyone thinks December 31st is a deadline. Everyone is thinking, I'm talking all residential customers, is thinking if they tell us to go ahead on December 15th, they're still in. Because of all the, if that's not the case, we need to have a public date announced so everybody is clear on it. The way this is reading, I take it as the deadline is actually December 6th, as there's 10 days application to send the application. There's 15 days for approval. That's 25 days back from December 31st. If the customer has it approved prior to December, even if the system is installed in November, and December 6th files the application, and within 10 days the application is complete and the facility is approved, is there and can we ask the utility company to give us the net metering agreements at the same time that the facility is approved to help out all these customers?
You know, if I might, the answer is, of course, you can ask the utility company for that. I strongly encourage anyone that's in this realm to talk with your utility company and to raise questions as they may be. As Mr. Olson pointed out, that the timeline that's on the screen before us is kind of the maximum that's outlined in the interconnection rule. And as Mr. Harden pointed out, a lot of these timelines, I guess Ms. Wheeler as well, a lot of these timelines are in there to assure the safety, the reliability, and the power quality of the electric system. And they're valuable that we assure that those pieces are there, frankly, whether it's a level 1, a level 2, or a level 3 review. So while these are kind of the maximum timelines, there's no guarantee of how it will happen. As Mr. Fulton pointed out, if in fact there's a significant number of applications that come into a particular utility at some particular point in time, it may simply be very difficult, if not impossible, to process all of them in a timely fashion. That's where the timelines behind us on the screen or in front of us on the screen are so important, because once we get beyond these timelines, the utilities will understand that any stretching beyond what is set out in the rule is something that we do not use as a reason why the customer cannot be net metered for 30 years, going to 2047. But if we get an enormous number of applications coming in, it may simply put us in a spot that we do need to use the timeframes that are set forth in the IURC rule and use them fully.
Okay. I would like to move on to the impact of repair, replacement, upgrade, or net metering facility. In the joint commenters' comments, they asked, they're referred to some sections that where a customer shall continue to be served under the terms and conditions of the net metering tariff until the tariff expires or when the customer removes from the customer's premises or replaces net metering facility. I think it would be helpful if IAA could briefly talk about what they think that means, because I think that would answer some of the questions that Ms. Wheeler presented earlier, and then we'll take some questions on that. I realize that we are technically at our 4 o'clock time frame, but we kind of realize that we'd be talking longer than 4 o'clock. So, but realize that we do want to be conscientious of people's time. So if Mr. Muzzle or Mr. Rushenberg, if you could
Thank you.
explain that.
If there are repairs to the net metering equipment, you're still grandfathered. Point one. With regards to the replacement of net metering equipment facilities due to damage or normal wear and tear, again, that'll be considered a repair, still grandfathered. But so long as, and this is key for all of this, so long as the capacity, the nameplate capacity remains the same size. So, for example, if you have a 4 kW system, solar system on your home, maybe you decide to put on the Tesla shingles. This, I guess, would fall into the upgrade part of this question. So long as the Tesla shingles, the upgrade, remains 4 kW, you're still grandfathered. Now, anything above the 4 kW, let's say you add through a repair, replacement, an upgrade process, let's say you add 1 or 2 kW to your current grandfathered original system, then that extra 1 or 2 kW would not be grandfathered under the 30 years. It'd be whatever the current paradigm is in place at that point in time. So if it's after December 31, 2017, you add 1 or 2, then it would be that 1 or 2 additional would be grandfathered until 2032. If it's after July 1 of 2022, then you'd have the distributed generation crediting system, which is the wholesale plus 25, applied just to that 1 or 2 additional kW that you added.
Yep. Ms. Arnold?
Laura Arnold, Indiana DG. Let me make you aware that we have had responses via utility customers of one who is in the room and other utility installers that at least 2 of the IEA members have indicated that a customer would not lose their net metering status if PV modules are added to their existing net metering facility, provided they are not adding to their net metering facility such that it exceeds the maximum AC output from the inverter listed on the interconnection agreement. and I have documentation to indicate that that is the position, and certainly one of the emails came from a utility person seated in the room today. So I would suggest the IEA discuss this issue further with its own members. I also heard earlier this week that another utility has also indicated that that was their position, and that came from another solar installer. So I don't know if you understood what I said, but there are people in the room, the utility people, that do understand what I just said.
Laura, can I ask a clarifying question? So what you're saying is that they could change the other equipment as long as it stayed within what was allowed by that inverter that was the original inverter that was attached? So,
Right. A central inverter would have a maximum output.
Okay.
AC output, and people are being told today, or they've been told recently, nodded head over there with a solar customer, because they have this in writing, that it's okay to add PV panels as long as they're not exceeding the AC output of the inverter that's listed on the agreement. Now, that's kind of a technical response, but this is where the problem is, where apparently policy people are not talking to the people who are in the field giving this kind of direction to installers and customers. This continues to be a problem.
Mr. Burkholder first, and then Mr. Rushenberg.
Just to clarify everyone in the room, if you have a example, 10 kilowatt AC solar inverter, and you put 50 kilowatt DC on there, that inverter cannot put out more than its AC rating. The term is labeled nameplate capacity and does not specify DC or AC. It should be AC rating. You could put 1 million panels on one inverter, it will not exceed its nameplate capacity output, but we need to stay with AC.
Mr. Rushenberg.
And I'm not as articulate, but we agree, the association with, I think, what Laura said. And that's the intent, certainly. In other words, if you have been grandfathered for that amount of what you generate, and if you upgrade to new technology, so long as you're staying within that amount, I gave the example of the 4 kW, then that grandfathering continues on. And we also agree with the comment with regards to the AC as well.
Thank you. Mr. Hardin and Ms. Wheeler?
I guess I have just one question in regards to that, because we have had customers that have asked a question in regards to, we install a 250 kW system now, but we have building expansion plans in the next 3 years of our budget where we would want to add an additional 250 or 300 kW system. How would that affect our net metering going forward if we get our system in by the end of 2017, but the new system is wanted in 2008 or 2019? These two systems would be fed, metered by the utility at the same metering point. How does the utility differentiate the two different generation sources for which one they get net metering for 30 years and then subtract what's going to be wholesale or rider 50 rates if it's all done through the same metering point?
Ms. Wheeler?
Thank you, and I just realized 170 IAC was in here after some earlier comments, and I appreciate your putting it in the packet because it's extremely helpful. But to the point of the inverter rating, if you look on page 18, which is 170 IAC 4-4.3-6, and I'm looking at D, which is starts at line 16 on page 18. It states that if the generator or electric source being utilized with the equipment package is consistent with the testing and listing performed by the nationally recognized testing and certification laboratory, which is the inverter rating these folks are talking about, which is UL certified, the equipment package shall be deemed certified and the utility shall not require further design review, testing, additional certification of the listed equipment package. which gets to my earlier point of it doesn't matter how much is flowing through that inverter why would the utility care as long as for safety and reliability purposes it's not being exceeded, which it can't be exceeded technically. So changing in and out a panel, which would impact how much is flowing through, shouldn't be of the utility's concern, and in my opinion shouldn't affect the definition of install.
Well, and if I may, I think what Mr. Ruschenberg said earlier, after hearing those comments, is that I think they're actually in agreement that the inverter that's installed, that inverter has its rating and what its output is, and that's what the utility is going by. And whatever you put behind that inverter, if you speak, as long as the output is the same, utility doesn't see that as a change that would affect your grandfathering. It's only if you're going to change that out, what's coming out onto the utility system, and that's just because, again, they looked at that interconnection point based on what you had applied for initially, and if it's going to increase substantially or be different in some significant way, they need to know about that, and then that might affect the grandfathering. Is that clear? Is that what, am I clarifying what you said? Is that?
Yes, we would agree with
that. Mr. Mazel.
Thank you. I'm sorry, I'm not trying to prolong this, but you asked a very good question. Again, Mr. Ruschenberg touched on it. If you have a customer that's building a facility, has built a facility, is looking to install a net metering facility yet this year, and then they're going to do an expansion in 2 or 3 years, how does that play out? In our mind, the answer is the portion that's installed this year is eligible for net metering underneath this year's program, in other words, would grandfather through 2047. The new addition would not be. It would be eligible under whatever that program is that's in place at that point in time. You suggested 2018 or 19, in which case it would be grandfathered through 2032. In all cases, of course, I'm going to remind everyone that you would need to submit to the utility company a new application, because once again, we'll need to go through the review process of the electrical demands placed on our system for safety, reliability, and power quality reasons. I will also just mention that there are actually 2 requirements in Senate Enrolled Act 309. They are reflective of what's currently in the net metering rule. And those 2 requirements are that to be net metered, you cannot be larger than 1 megawatt, but you also cannot exceed your average annual consumption. And the rule has a slightly different phrasing for the same basic concept. So to go in and try to deliberately oversize the unit is something a utility will be reviewing, because there's these 2 criteria to make you eligible for net metering. And again, they're in the statute as well as the current IURC rule.
Okay, thank you. If there,
I think Mr. Harden also asked, how would you meter it? Would you have a separate meter? How would you handle that?
Yeah, I tell you, it's a marvelous question, and what we're talking about, of course, is installations that could potentially be under a pricing regime from now till 2047. As the Commission is fully aware, utilities are looking at and beginning to install what's kind of generically called smart metering, very sophisticated kinds of meters that have remarkable capabilities for what they're able to do. As that technology is installed and as that technology unfolds, the answer of the metering may become a lot clearer than what it might be today. We're trying to simply articulate today to everyone in the room and listening on the webcast how we look at this, and we're looking at it based on what the statute provides by way of guidance. If there's a metering issue, again, you need to talk with your utility. How they may handle it in the near term would be different than how they might handle it in the future. They certainly have that flexibility and recognize that metering may or may not be able to really, easily and cost effectively do it today. That does not necessarily mean that in the future, when we do in fact have improved technology, it may not make sense to go to what we're describing today as our basic position.
with that, I'm not seeing any additional hands on that particular point. So let's go on to the meaning of successor and interest. I just note for the record that the Black's Law Dictionary definition of successor and interest is one who follows another in ownership or control of property. I realize that there's a lot more questions around that, and these questions were raised by the, I'll call the Joint Commenters Group, so I don't know if you wanted to express those questions further or what you think needs to be clarified, would be helpful to be clarified.
Well, I think that we believe a successor in interest would. Really? I've always been told the opposite. I guess we believe that a successor in interest would be anybody that would move into that property and take over the electric bill for purposes of this chapter, which would include a renter. But we also have concerns about how it will be documented that net metering is available at a property until either 2047 or 2032. And so, it's our position that, documentation shall be conveyed and recorded on that property available to realtors or leasing agents or other things that property had solar, had wind, or other technologies and was eligible for net metering until a date certain. How will people know that is in place?
Okay, so what you're suggesting is that there would need to be some kind of documentation that gets recorded, the same that you would with any other property interest that you want to make sure it gets passed along.
Correct, but I would also note for purposes of interpreting that with respect to the law, Senate Bill 309, we would think it would also be tied to the utility bill as well. So if a property was rented or became a rental or something like that, that the net metering would be available to whomever was paying the utility bill.
Any other comments or questions on that issue? We will, again, we're looking at what we need clarified.
It sounded unanimous.
Yes, I know. Silence is golden. Okay, so the next one is nameplate capacity. This was raised by the comments in Bose, McKinney, and Evans. Ms. Wheeler, I don't know if you wanted to speak to that first or.
Thank you. I think it was already addressed with the comments about AC versus DC and the recommendation that it be AC. My only comment is whatever it is, we just need clarity so that we can plan accordingly.
Mr. Ruschenberg, want to comment?
Well, we just want to point out that nameplate capacity is already defined in the interconnection rules and defer and support that definition.
Okay.
Yes, ma'am. Sorry.
Okay, any other comments on nameplate capacity? Mr. Harden.
I will state real quickly that I believe the utility has been clear in that definition of being AC rating, not DC rating.
Okay, thank you. Other questions or comments on nameplate capacity? Then the next subject matter is the 1 megawatt cap, whether that's per meter or per customer basis. And this was raised in the comments by the joint commenters.
Well, we asked that question because there's different interpretations out there. Most utilities believe that 1 megawatt cap is a per meter cap, but there is one utility in particular who views that as a 1 megawatt cap on a customer. For example, a school campus that may have multiple meters or a business that may have multiple meters, that 1 megawatt cap would apply to that customer rather than that meter. And we believe that the 1 megawatt cap should be a per meter cap and not a per customer cap.
Any other comment?
As the majority of utilities agree with.
Okay.
Well, we would disagree with that.
Sorry.
Oh, I'm sorry.
Mr. Ruschenberg, did you have a comment?
Yes, we
Okay.
disagree with that. And there's a couple of different
You
references.
need to talk into your microphone just a little bit more.
We believe it to be per customer and not per meter. That's the position of the association, certainly. And there's several references. I'll just touch upon two for sake of time. Under Senate Enrolled Act 309, Indiana Code 8, this is on page 4 of 38. Line 11, it's the definition of distributed generation. It talks about the customer's average annual consumption of electricity on the premises. It defines premises as a single tract of land on which a customer consumes electricity for residential, business, or other purposes. That is on page 5 of 38, line 7, the definition of premises. So you have those two definitions within Senate Enrolled Act 309. And then also in the net metering rule 170, which is on page 10 of 38, definition of net metering customer, line 30 down to 36, again, it refers to, under the definition of net metering customer, a customer in good standing used to offset all or part of the net metering customer's own annual electricity requirements. A lot of references to customer there, and therefore believe that it's a per customer basis.
Mr. Olson?
Well, first, I would point out that if you look at page 4, line 21 through 23, that the definition of distributed generation, first of all, does not include net metering facilities. Secondly, I would point out that with Senate Enrolled Act 340, with respect to the opt-out, we believe the opt-out was a 1 megawatt per meter, not 1 megawatt per property. So consistency, there would be some precedent there and some consistency with respect to the 1 megawatt opt-out on DSM tariff was a per meter 1 megawatt. And again, the majority of the utilities do interpret it as 1 megawatt per meter, not 1 megawatt per customer.
Okay, thank you.
Trying not to name names.
Okay. Any other comments?
I'd be more than happy to point out other references to customer, but for sake of time I won't. But it's within the definitions of, again, Senate Enrolled Act 309, clearly references to customer, not meter. But I just want to point that out for the record.
Thank you, Mr. Eschenberg.
If I could just for clarification, Mr. Olson seems to have some examples where maybe some of your members do by customer, some by meter. Is it your position that they would have the flexibility to do either, but you're saying that they're only required to do by customer? Or how would you address that, assuming that's the case?
In terms of flexibility for the utility, I think we do have flexibility under the net metering rule and also under the new law under certain circumstances. But in terms of the interpretation as an industry viewpoint, we certainly believe, based on the adoption of Senate Enrolled Act 309, that it's certainly a per customer basis. In terms of what individual utilities may have done in the past with regards to a particular customer too, I can't address that because I just don't know.
Well, just to be clear, what about going forward if individual utilities decide that?
Let me maybe just give a couple examples as Mr. Olson did, and perhaps from there you can if I'm missing the target, you can point me in the right direction. The two examples come to mind. Let's go to the school facility that he referenced, and let me just assume for a moment that while it's a single building at this point, it was actually built and there were several additions to it, and you have 4 separate meters there. The 4 separate meters total up to some number, whatever it is. That school would be able on their property, and they could install and own a system up to the total of the 4 meters, their average consumption for that entire building. They could put one solar array, one windmill to serve that entire building, and that would be appropriate because it's a single customer premise. The second example would go the other way. What happens if you as an individual own 5 retail outfits and they're in 5 separate towns, all in a single utility company's service territory, but 5 separate communities? There you would not be able to accumulate that usage among those 5 meters. You would go to each individual store and say, what's the use on this particular premise? I can install a facility there that meets the net metering rules and be able to net meter, but at the size specific to that particular store, as opposed to trying to accumulate the meters. Yeah, I agree. The normal rules for net metering still apply. Cannot be over 1 megawatt, cannot be above your average annual consumption. Good point.
Mr. Harden?
Did that help? I'm sorry. Go right.
Just to clarify, in the case of a customer that has 5 premises under the same utilities service territory, that would be up to 1 megawatt per premise, per metered premise, correct?
Yeah, and of course, ultimately it would be, and I apologize, is it okay if I answer?
Yes.
I'm sorry. The answer from my viewpoint, from our viewpoint as the association, would be yes. They could go to each of those individual sites. They would have to, again, meet all of the rules necessary to be a net metering customer for that site, again, so 5 different times in your example. And I should point out that they would need to be talking with their utility repeatedly because there is the overall issue of the 1.5% cap and the timing on those various issues. So again, you should be communicating with your utility constantly.
And just for further clarification, in the case of a school facility, as you mentioned, that may have 4 metered points on their premise, and they can install a 1 megawatt system, would that system be expected to have a primary connection and the 4 metered accounts be aggregated together for billing, or would that be the system broken up into 4 separate systems and secondarily connected to the school system? When I say primary connected, I mean connecting on the utility side, and when I say secondary connected, I mean connecting on the customer's equipment.
So you would want to talk directly with the individual utility about some of the billing questions and so on. I can tell you that no, this does not allow a customer to use the utility system. To the extent that you're going to try and generate electricity, put it up onto our wires and move it over to a different facility, even if it's around the corner somewhere, that the rule, the law, Senate Bill 309, specifically limits that is not a possibility. So to use your terminology, it would have to be secondary. It'd have to be wired on the customer's premise for their facility, their net metering facility, to serve whatever buildings or other things they may have.
Just to clarify, in the case of a few of our installations, we do have systems that are installed where the customer has primary connections with multiple accounts that are aggregated together to be metered at that one connection point back through billing.
It's a fair comment. Again, what has changed between whenever those systems were installed and what we're talking about today is the enactment of Senate Enroll Act 309, which gave us a blueprint, a direction for how we should be working on a going forward basis. So our view in reading that act, along with the interconnection and net metering rule, you've just heard me articulate.
Are there any additional comments regarding the 1 megawatt cap? Okay, let's move on to the calculation for average annual consumption. This was also raised in the Bose McKinney-Evans comments, and Ms. Wheeler, did you want to provide some comments on that?
Sure. I think the main issue around that is what is the 12-month period that we're talking about for purposes of calculating average annual consumption. Is it the 12 months prior to the application date? Is it some other period of time? And is the customer ever going to be caught in a situation where their future average annual consumption changes, not necessarily because they changed their system at all, but perhaps usage by the customer changed or other circumstances caused a change like weather? And is the customer then going to be in violation of those provisions because at a future point their average annual consumption changed and they then exceeded a threshold they didn't exceed at the time that the equipment was installed and the application was approved and the interconnection agreement was signed?
So just to clarify, so I can understand your question, you're asking so that what's the 12-month period that the annual average consumption is determined, and if that's a one-time determination before you install your equipment, or is that some kind of ongoing determination?
Yes.
Mr. Ruschenberg, do you have a response for that?
Yes, our view is it would be the 12 months of historic annual electricity usage prior to the installation of the net metering equipment. So it'd be that prior 12 months prior to the installation of the net metering. That's how you would determine the average annual consumption is.
And well, let me add, just to answer Ms. Wheeler's comment, no, this is a one and done kind of thing, because you will have installed your net metering system at that point in time. We're not going to go back and tell you you have to take out half your system because your load dropped. Incidentally, it is important, as Ms. Wheeler pointed out, that there may be something that's gone on. It may have been an unusually cool summer where the average annual consumption might have been less than it is. frankly, from a utility standpoint, we will be talking with the customer about, gee, did you just install energy efficiency? So it might be an unusually high consumption. And that's the value of going through that immediate 12 months with discussion with your utility. So to your comment, if you're looking at a period where it's an unusually cool summer or something else that you see going on, again, I strongly encourage you, go talk to your utility and just say, what is it? How do we handle it in this specific situation? Generically, on a high and wide basis, it'll be the 12 months immediately preceding.
If I could just say, the net metering rule in its base is premised upon the customer citing themselves so that they don't have excess generation past an annual basis, right? So, I mean, it's in the customer interest not to oversize themselves because they have no ability to monetize their excess. It's just going to keep rolling over until they burn it off, right? So, I mean, I think it's fair to look at what your nominal usage is as a customer whenever you're deciding what size system you're going to make, and that's one of the things your developer should be helping you do.
And then we have a comment from Mr. Burgess.
Daryl Boggess, again, B-O-G-G-E-S-S. I was not expecting to speak more than once today, but I had overlooked this part of C-309. It has a personal impact on me, so I have an issue with this. As I told you, my solar array's been operating quite satisfactorily for several years. I didn't tell you that before I put it in, I checked my history of our house that we lived in since 1977, and I was surprised. For the 2 previous years, the total for 12 months, first 12, second 12, were almost identical. It was very close to 7,000 kilowatt hours each year. It was within about 100. I couldn't believe it. But that was the ceiling for how much solar I could put in. I didn't want to overproduce. But at that time, it was expensive, so I didn't put in that much. We put in enough for about half, which is all I could afford to pay at the time. But soon after, we did a few other things. We put in about 3 feet of insulation in the attic instead of a few inches. We adjusted our thermostat so it's warmer in the summer. Don't use the air conditioner so much. Makes a big difference. Walk around with a tank top and shorts, barefoot in the house. I can tolerate it. So we really surprised ourselves. We also upgraded an ancient refrigerator that we discovered was consuming almost 2,000 of our 7,000 in the kitchen. So I went shopping at Lowe's and bought a Energy Star that was on sale and a few other things like that. We had another refrigerator in the garage. It was mostly empty. We kept it for Thanksgiving and Christmas, but then my daughter decided she got a bigger dining table, so we'll eat with her. Put the food in her fridge, so I put our fridge in her garage. And now her kids keep it full most of the time, no problem. She pays the electric bill, we don't. So within 6 months of getting our solar system, we had effectively balanced our house. And ever since, if you look at the history of our house, the last 12 months, the previous 12, the 12 months before that, we don't have any. We produce everything we need, which is about half what we used to use a few years ago. So that brings me to the present. The reason I want to upgrade my system is not because there's anything wrong with it. I want to get an electric plug-in car, which will, depending on how many miles we drive, and we have 2 cars, so I could drive the electric or drive the other one, depending on the range. I live outside Indy, so if I want to come here and I want to get back home, I might drive the other car. But if I put in the application to increase my size for the car I haven't bought yet, and somebody looks at my history and says, I don't have any history, and the application is denied, that means the car dealer just lost a customer. That has a direct, immediate impact on my lifestyle. I'm looking at sizing my system going forward 12 months, not backwards. So I think that's a factor. I have friends who are in the same situation. Indianapolis is noted nationally for supporting electric vehicles. Indiana is noted nationally, believe it or not, for the high ratio of solar energy produced per capita, partly because of the solar farms right here in Marion County. So if we want to continue that reputation, if we think back, the reason we're here is because of the net metering rule. Why do we have a net metering rule? It's an incentive to encourage people to use more renewable energy. That's why we have it. The commission had hearings around the state several years ago to come up with the current rule, which I think was pretty effective. And since then, we have now accomplished, we have succeeded by increasing renewable energy in the state of Indiana with net metering. We're close to 1/10 of 1% of the peak load for the previous year. If that's a measure of success, I think we have a way to go. And if electric cars are in the future, we need to figure out how to accommodate that. And looking at the history of my electric consumption for the last 12 months doesn't get us there. We need a different way of looking at it.
Mr. Mousel?
And I would actually agree with that. As I was discussing in response to Ms. Wheeler's question, that's where a discussion with your utility is important. There's no question that the immediately preceding 12 months may not be reflective of what the future will hold. That is the discussion that needs to occur. What I'd like to just repeat is sort of the normal approach, the way that's probably going to work in, 80 or 90% of the time. We'll take the immediate preceding 12 months and look at that to determine the average annual. Again, if there's something going on, please talk to the utility.
Any other comments on average annual consumption? Moving on to the impact of battery storage. This was a comment made by Rectify Solar, Phil Teague, and basically he said and I'm just going to read it. It says, I would understand if the commission deems that batteries, if installed without a solar system, would not qualify for net metering. However, with the batteries being installed as part of a solar system, I believe the grid tie solar plus storage should be included for net metering, both DC and AC coupled solar systems. So I don't know if anyone wants to comment on that particular question. Ms. Arnold?
Yes, Laura Arnold, Indiana DG. Phil Teague is one of my business members, and he had shared with me an email exchange that he had received from one of the members of the IEA, and he was flabbergasted, I guess, because we have other solar installer members who are installing battery backup systems with their solar systems with other utilities. So we never even contemplated that that was a problem or an issue. And I think the only other thing that Mr. Teague and I discussed is that there is discretion on the part of the commission if you think that it does not qualify. And I understand an energy storage system by itself without a renewable energy system, you could say no, does not qualify under the definition of the technologies for net metering. But when it's clearly associated with a solar system, we think it's very clear that yes, an energy storage system with a solar system should qualify for net metering. This has only been a problem so far with that I'm aware of. And generally when there are problems, people pick up the phone and they call Laura. So it has not been a huge problem, but it is a increasing issue as more and more people look to energy storage. People who want to or have on order those new Teslas and they want to have a power wall and all this kind of stuff, and they want to have a solar system to charge their new electric vehicle. it's one that we think should be clarified by the commission.
Thank you. And any other comments on that? Mr. Ruschenberg.
I'll agree with Ms. Arnold to a certain extent that on their own battery storage systems do not qualify for net metering. They do not generate electricity. They're not listed in the Indiana Code as a qualifying technology. The second part, net metering system with a battery is fine so long as it is used for backup only. That's the position of the association.
Can you clarify what do you mean so long as it's used for backup only?
Well, so long as it's used as similar to what a backup generator would be used, similar situation in terms of the use of the battery system. Very similar.
Okay, you caused a lot of hands to raise. Mr. Hardin and Mr. Burkholder.
I guess in that regard, where a battery storage system is coupled with solar, how does that apply to anti-islanding not being able to be used as a backup facility if there should be a outage on the grid?
Mr. Hardin, did you want them to reply before Mr. Burkholder comments?
Yeah, I'm sorry. That was a question for clarity where you said it was used for backup, but if it's coupled with solar, solar cannot be used as a backup system. Coupled with the battery, they would be tied together.
They would, absolutely. So the question really was, where he started with was, would, in effect, a little different slant on it, if we installed a solar array and then we installed a battery system at the same time, would installing that battery system somehow disqualify you from being a net metering facility and being able to take advantage of net metering? The answer from the association's viewpoint is no. Even though you have added a battery to your solar panels, that is net metering. When you have an islanding situation, in other words, an outage where the utilities grid is not providing power to that facility at all, and if it's solar, for example, in the middle of the day, you will continue to generate electricity. The battery's sitting there. That is an islanded facility. It's not taking anything from the utility. That's okay. That is still not going to impact the net metering. That's the importance of those disconnect switches or the automatic disconnect that's kind of inherent in the inverter, because you want that isolated from the utility system so you don't endanger anyone that's on the utility side of that wire. So hopefully that gets to the point. The point is not that you may use it in an islanding situation. That's exactly when you want that backup. It would be very similar, I suppose, to the battery you might install on your sump pump. In the normal course of the year, that it's going to be taking electricity from the utility to keep the battery charged. If there's a utility outage, then it'll run the sump pump and you'll discharge the battery. Same basic notion here.
Okay, Mr. Burkholder?
So I guess I'm not clear. If as long as we have a solar and a battery backup system, it is in net metering and they're grandfathered as long as they're in this year. Is that correct?
Yes, unless for some reason you size the battery vastly more than what the solar array is.
Would your concern be that then they'd be pulling electricity off the system into the battery?
Well, once again, you get into the reliability and the safety of the system, because now you're changing electrically what's going on. So if you submit the system and it has the net metering facility, the battery as a backup, it should all be fine.
So your normal connection of solar and battery would be okay,
Would
is
be
what you're
fine.
saying?
Would be fine.
And if I can suggest, I think we're a little bit ahead of ourselves on this particular question. As long as you're in net metering and you're not in a time of use rate, you don't have the ability for the battery to help you out, if you will, to kind of not game the system, but utilize the system. Once you get into a time of use rate where your battery can serve to take off the low energy cost from the grid and then put it back on when it's in the high energy cost period, that's whenever we'll have to address this, whenever time of use rates come into play, really.
Any other comments on the battery storage question? Okay. I guess we need to take a break to switch out the paper. It'll be a very brief break because I think we're almost through. So,
How much do you have left, Amy? How much paper do you have left?
Short comments. That's a very unfair question.
So I didn't see any more questions on battery storage. And so let's go to the next one, which is complaints to the IURC Consumer Affairs Division. This was a question asked on the Bose McKinney Evans comments about whether the Consumer Affairs Division intends to continue to take consumer complaints regarding net metering. And I think the answer to that is yes. We understand, and I did hear Mr. Olson, the comments you made earlier about the need for, maybe a faster process to final determination of those kinds of things, and that's something I'm sure the commission will take under consideration. But at this point in time, what is in the net metering rule and in the interconnection rule is that the appropriate place for those complaints is first to Consumer Affairs. Ms. Washburn.
Thank you. Jennifer Washburn, counsel for CAC. Just two brief points that I wanted to reiterate. One that I think Mr. Olson already raised with regard to how the commission ends up interpreting the grandfathering provisions and whether or not this or any timeline is going to be stalled while a customer is going through that complaint process. And then I also just want to mention the enormous costs and resources that it takes a customer should it arise to a docketed proceeding, and how the commission might try to accommodate some concerns about customer resources, especially as they're trying to navigate this brave new world of 309.
I think that's if I could just say briefly, that's a very good point, Jennifer. It's never our intention to require a customer to have an attorney to come before the commission. I've been meaning to get together with Councilor Fine at some point I know they don't take positions in these kind of complaints, but they may be able to provide some legal assistance procedurally just to help citizens along so they don't have to incur the cost of an attorney. It's certainly not our goal to require them to have to hire, sorry to the attorneys in the room, but I don't want to have them hire an attorney to come before the commission. And I see your point is well taken on that front.
Thank you, Chairman, and they're definitely disadvantaged with not having an attorney. Yes, thank you.
Thank you. Any other questions or comments regarding the consumer complaint process?
Real quick.
Mr. Ruschenberg.
It's our view that complaints about the utilities, whether it's the timeline or any of the rules that we've been discussing here, would go to the commission, and complaints about installers would then go to the Attorney General's office. I do want to stress the point, Mr. Mausel's been hitting this. Obviously, if there's any issues with any individual utility, we emphasize and stress that any customer should certainly work with their utility. That should be the first call they make.
Thank you. I have both of you raising your hand. Is Mr. Olson or Ms. Washburn going first?
When we're in here, I will defer to Ms. Washburn.
Thanks, boss. I would just reiterate again, if they are starting a complaint process, and I can certainly understand the desire for the utility and commission and others to work with the utility. Again, at what point does that toll the process, even if they are trying to resolve that informally, considering how critical the finances will change at the end of the year.
Mr. Olson, did you have something additional?
Yeah, I just wanted to note, Mr. Rushenberg did mention Section 23 of the bill for reasons unknown to me, I guess. And so does that mean that the Indiana Energy Association and member utilities believe that Section 23 of the bill applies to current net metering customers and solar installers out in the field? And if so, then I think that should propel a second discussion with the AG's office and the IURC. As we noted in our comments, we said we're not sure that Section 23 does apply to net metering customers, and therefore, we didn't expect it to be mentioned today, but it just was. So I guess we're curious about the commission's position on that. And then I would also say that both our joint comments and also, I believe, Chris Bowe's comments as well spoke to the capacity and the set-asides that were in Senate Bill 309, both with respect to residential customers and biomass, and that's of great concern for many, many reasons. And I think that's a relevant topic that I guess we'd like to get some idea and guidance what the commission is thinking before we leave today, because that's a big deal.
First, I'll let, if Mr. Mausel or Mr. Rushenberg, considering you guys brought it up, if you want to respond to Mr. Olson's question.
Mr. Olson asked what the IEA's position is on Section 23. I recognize as well that this is really not a topic for today, and again, I can't speak to what the IURC may or may not believe, but the IEA's view of the world is the Attorney General should read the statute and make the determination the Attorney General believes appropriate and then proceed down that path. So I can't begin to predict which way they're going to go. They are aware of the statute. Obviously, they're in attendance today and will make the determination that the office believes to be appropriate.
Okay. Mr. Burkholder.
So as far as filing complaints, I do have a question. Going back to my very first comment on the 73 days between point A to point B of interconnection, where does the customer go to file a complaint? We have talked to the utility. We've been told they're in training. They're busy. They're on vacation. There's trees down. The list is endless, which is why there's 73 days. So what's the next step in filing a complaint? We've tried to talk to the engineer. We've talked to the Board of Engineers. What's the next step?
Well, under our Consumer Affairs Division rules, I mean, you just have to attempt to have resolved it with the utility. Once the customer has attempted to resolve it with the utility and it's still unresolved, then you can contact our Consumer Affairs Division. That contact can be made via phone. There's an 800 number, it's toll free, or online. There's a process to submit a complaint online. If you need more information on that, we can definitely provide that. And I see Laura waving at me that she'll tell you how to find that information too. So there's definitely a process to do that. That will be assigned to a Consumer Affairs complaint analyst, and they'll then contact the utility. They have separate contact people, and then it'll proceed from there. But there is a process. It's on our website. We have an 800 number. We have ways that they can call, and it should happen. I would say if they miss that deadline and you contact them once and they don't respond, then this is, according to our rules, that's the next place that you can go. Okay? And then I know, I'm suddenly seeing a lot of hands going up, and we have 9 minutes left. I think Mr. Olson and then Mr. Johnson.
Just two quick comments. First of all, you said if you attempt to resolve it with the utility. However, I would hearken back to the comments we've made about the timeline that's on there, and does a complaint stop that time clock? Day 11, from my perspective, is the time to file a complaint. And so attempting to resolve it with the utility could take a long time, especially when you have to call folks out of state.
Well, and you have to, Corinne, with Mr. Olson, with all due respect, you have to actually read our Consumer Affairs Division rules. It says you have to contact the utility. It does not say it has to be resolved, that you have to go through that process. You have to have contacted the utility first.
I understand.
And so that contact can be a 5-minute contact. It doesn't have to, we're not talking about a 2-week contact.
I understand. And the other thing I just want to point out real quick on Section 23, Section 23 does not say anything about regulating solar installers. It's supposed to be a customer bill of rights. I just wanted to point that out.
Thank you. Mr. Johnson.
My concern with respect to this is less with a end-use customer and more with a installer. To be clear that nothing requiring resort to the Consumer Affairs Division in a first instance, that should not be taken to apply to an installer who might have a legitimate business-to-business dispute. And I say that because I believe that's where problems are more likely to arise than at the customer level because of who will have the resources to bring the complaint. And secondly, while the Consumer Affairs Division can be helpful in dealing with individual customer complaints, probably on a business-to-business dispute, that needs to go directly to the Commission, and I would not want that to be used as an additional hurdle that an installer would have to meet or take, again, causing the clock to run further before it ultimately would get to the Commission. So to the extent the Commission's issuing any guidance in this regard, I hope it would distinguish customers between individual customers and installers or commercial customers who may not be a customer in the electric utility sense, but could be perceived as part of the customer group of the utility.
Thank you. Are there any more comments regarding the Consumer Affairs Division complaint process? And then with that, are there any additional questions or comments? Mr. Mausel raised his hand.
I'd simply like to address the topic that was raised today of this idea of perhaps staying the process, if you will, if there's a complaint filed. Let me suggest that, again, looking at the timeline that's before the Commission, the utility commitment is that if the customer is meeting their requirements underneath of the interconnection rule, and for some reason the utility takes longer than what's allowed underneath that rule, in Mr. Olson's example, day 11, the answer is now there's a day extension, if you will, in terms of whether you're going to be able to net meter under the current program that's in place through the end of this year. I'm not sure I see the need for a stay, given the fact that utilities are not going to try and somehow keep customers from net metering. If there is a delay on our side, we absorb the impact of that delay, not the customer.
Ms. Wheeler.
Thank you. In closing, I would like to note that while I recognize there's very little, or if nothing, the Commission can do about the December 31st deadline in Senate Bill 309, there are many things that the Commission could do that I'm sure you're probably already considering in your own minds to help customers and utilities clarify what's in this process. As we've been talking today, I made a few notes on what those things could be. You certainly, in your discretion, on an emergency rule basis, could shorten this timeline that we're looking at right now to shorter than 45 days. You could require that portions of the things that are required under these rules be done simultaneously on a parallel basis, which I believe Mr. Mossel indicated at least some of the utilities are already doing or have done in the past when it's appropriate. You could require that all communications with customers happen via email. That helps the documentation process and concerns that have been raised today. It also could help if you're shortening the time frame to speed this up. It sounds like most of the time that does occur. You certainly could, I recall, and I don't remember whose comment it was, but I recall one of the solar installers saying that often they were not copied, that the utility is only communicating with its customer and not communicating at all with the solar installer. You certainly could require them to do so or change their application so that that contact information is available to them. I'll also note that the time frame for providing the interconnection agreement could be shortened. Those interconnection agreements aren't subject really to any negotiation. They're part of the utility's tariff. They're on file. Is it possible that that could be shortened? You also could create a rocket docket, both for Consumer Affairs Division complaints, similar to other rocket docket proceedings that the Commission already has, or by formal complaints filed by solar installers or groups of customers or other interested parties. And you certainly could address the issue of whether these timelines are stayed, stalled, or whatever, and what effect those complaints have on the timeline that you sent. So I appreciate the opportunity to just present those ideas as they popped into my head as we were talking today.
Thank you. Any additional questions or comments?
Yeah, one last one. Under Senate.
Last one, Mr. Rushенberg. I'm going to hold you to your word.
I can't help myself. Senate Rolled Act 309 greatly restricts, rightly or wrongly, but it does, right there in black and white. Page 8 of 38, line 26 on down, Indiana Code 8-1-40-21 in terms of the rulemaking ability of the commission under this bill with regards to net metering and interconnection rule. I don't believe the deadline can be changed as listed in the interconnection rule. We certainly don't believe that. There are some things you can change with regards to the 1.5% and some other things, the biomass and some other things that are addressed in there, which are clearly laid out here, but certainly not the timeline.
I think Ms. Wheeler herself pointed out that the timelines were set because there are safety implications to some of these systems. And so getting things installed, especially if we begin to see a large number of either new applications or complex applications, is going to really pressure the utilities in order their ability to meet those obligations to ensure the safety, the reliability, and the power quality of the system. So I think they're beyond the General Assembly guidance. I think there are some very important issues that are inherent in that rule.
Thank you, Mr. Mazel. Ms. Washburn.
Thank you. Jennifer Washburn. I did want to note, again, for everybody's reference, to please take a look again at the Consumer Complaint 44344, where the exchange of paperwork and documentations, agreements going back and forth, that was discussed ad nauseum about just trying to shorten those timelines and the ways by which that could be done within the context of the rule.
Any additional questions or comments? Ms. Arnold. And then Mr. Harden.
This isn't a real comment. It is a procedural question. Is the commission receptive to receiving further written comments based on the discussion today, or is that encouraged or discouraged for any particular reason as to how you believe the commission intends to resolve this matter?
Based upon our conversations with everyone today and previous conversations with many installers, many various groups, many of the folks in this room, it seems imperative that the commission give some direction quickly. So the longer we leave this open for comments, the longer that process goes. So I'm torn because certainly we would welcome additional input, but at the same time, we're trying to get some direction out as soon as possible so people can have a sense of the timeline so they can market appropriately and then plan appropriately. So that's a sort of a political answer, I guess, in the sense that, yes, they're welcome, but at some point, as we begin to render a decision, we're going to have to do it sooner rather than later in order to give the appropriate direction.
There are some people I know that are watching online because they've sent me messages, and we've been trying to live stream ourselves on Facebook so that people can see or hear this, that we're not able to be here today because they're up on a roof. You know, they're actually working. So they may have questions or want us to clarify as a group, and I just wanted to make sure that we aren't doing anything that's viewed as being inappropriate.
That's fair. And you were kind enough to bring in some of your members the other day, and we had a great conversation with them, and their points, again, were also well taken. So I guess the answer to your question is yes, but in order to expedite this process and get some direction out as soon as possible, which seems to be the will of everyone in this room, we'll try to balance both of those dynamics.
Mr. Harden.
I just want to appreciate a comment made here a second ago in regards to the quality and safety of the systems, and again, why we emphasize that we'd like to see the focus of this being on the interconnection application being approved by December 31st and less in focus on the installation due to safety reasons and quality of design and proper review process done by both engineering parties and the utility to ensure that systems are being installed that don't compromise the integrity of the grid, but also are good systems that are out for the customers, because, again, we're backloading the end of the year where there's going to be a lot of constraints put on these systems being installed, and installers like us being pushed to meet this December 31st deadline on both paths.
Thank you. And then I think this will be near final, but we actually asked the Indiana Energy Association to put together with their members contact information so that people who are interested in this know who they should be contacting at the utilities. We asked them to go ahead and pass that out, pass out the contact information. We'll also post that online. Also, the presentation that you saw today, we will post online. That should happen. Give us till early next week, but that will happen as soon as possible. Anything further, Mr. Chairman?
I'd just like to thank everybody for their time and their input today. The commission will take under advisement the statute, the commission's rule, and everything we've heard today. And then we'll be hopefully providing some guidance within the next few weeks that will be instructive and hopefully helpful, at least to give some certainty and clarity. I'm sure we won't have 100% agreement based upon the conversations we've had today from everyone in the room, but hopefully it'll give some positive guidance and some direction going forward. Again, thanks for everybody's time. Good to have everyone here. Hope you have a safe drive home. Thank you. We're hereby now adjourned.